matter is called. All right?
As your lordship pleases.
Lordship, I may be pardoned to mention, Lordship, I may be pardoned to mention.
Please wait, sir. Please wait for a minute. Yes.
Fresh content matter, my lord. Fresh content matter not listed.
Contempt, no contempt is urgent, sir.
Last more than 1 year, my lord, they are not getting.
No contempt is urgent because in contempt proceeding, the only thing which can be done by the court is either to punish him or to acquit him. That is not urgent for you. Wait for some time. We are taking up contempt matters. All right. Please wait. Yes, sir.
Sir, this is a elephant corridor matter, Lordship. This is the public interest litigation and the Rabi cross being severely damaged. The repetition number is 14
We will see.
by 23.
We will see. Send your slip.
I have sent the mail.
We will see. We will see.
Lordship, as your Lordship, please.
Yeah, absolutely. All right. We follow. Yes.
Special admission item number 1.
Your lordships have heard the matter. Your lordships wanted that if anything can be worked out so as to help the employee. I have already proposed them, but because of this financial year ending, they cannot bring it to the board's notice. So if your lordships can grant me for further 4 weeks' time, because 5th will be there, 5th of May will be the next board meeting.
All right.
Subject to
Yes,
my
please.
consent.
Please.
We'll try, we'll endeavor whatever the level best, my lords.
As jointly requested on behalf of the parties, with a view to explore the possibilities of amicable settlement of the dispute, list this matter on 4 weeks.
After 4. Well, there's an interim order that may be continued in all the matters.
Interim orders will continue in the meanwhile.
Obliged.
Item number 2.
My lord, in this matter, on 15/3/24, my lord directed if the CCA rules, my lord should remember.
That was the question.
My lord. And we are examining the matter, my lord, regarding, because it will, once we come up to this honorable court saying that it is applicable or not applicable.
Very important, yes.
My lord. So, my lord,
(2006) CC Bihar, sorry, Odisha service.
1962. That is derived from the Police Act of 1861, my lord.
yes, 19.
Maruka, kindly give me another 2 weeks time. 2 weeks, not more than that. Meanwhile, please work out. We will be filing an affidavit.
And just verify whether the rules are still in force or not.
Policeman,
Report.
where is
62?
amendments in the rules, but the 1960 rules apply.
Applies.
Absolutely. Absolutely.
It's
Rules,
still
it governs all the government. Right.
Get it?
Yes. You also please work out.
My lord, so far my introspection is concerned. So this police rule of 1860 has statutory effect, my lord, because that is derived from the.
Examine that. We will examine that.
Because as per Article 313, the temporary provision, this article, this rule is not derogatory to the associates CCS rule. That is why it has a statutory effect.
There are two, three reasons why the court is observing. If you have worked out and no research is further required, then you can stop.
Right.
All right, we will hear you on the basis of whatever you have.
Right.
The first question is whether part of the rule which we are considering in the part of the police manual, which we are concerned in the present case, has a statutory force or not. This is one. The second question is, after 1962, whether the provisions of the police manual apply or not. Third, whether the police manual itself has statutory force or not. These are the questions which require consideration. So if you have examined all these aspects, it's all right. The question, because whatever answers are there to these questions, they will have very wide ramification. Therefore, I would invite the suggestions from all the any senior counsel or counsel to address on this point.
And I am going through
Overlapping effect. Overlapping effect is also there because there are two people.
They have to hold that this provision is statutory and that provision is.
I am going through the 2002 judgment of the Supreme Court. There this view, as so far as no special law is made by the state, like some other states have made, like West Bengal. So this rule is not derogatory to 309, Article 309. This mail.
You are so convinced that everything is, we may accept all of your submissions.
My request.
All right. It's good that you have done your homework. As requested on behalf of the state. So as to comply with. So as to comply with this court's order, last order. There's this matter of. So as to deal with the questions raised, the order dated. Last order, yes, this matter on.
Trace admission item number 3.
May I please, Lord? In this case, petitioner challenged the judgment dated 10/11/23 passed in WPC no 40,421. And the case is that the husband of the present petitioner died in a road accident manner, and two daughters are seriously injured. Therefore, he was filed one claim before the insurance company. His claim was repudiated as at Annexure 3, page 15.
Yes.
Only on the ground that the driving license of the present page 15 matter. Your above mentioned claim stand repudiated for the following reason. The insured owner cum driver of late Mrityunjay Prasad Kesari was not having a valid and effective driving license at the material time of accident dated 21/4/29. The DL of the late Mrityunjay Prasad Kesari was valid up to 2/4/2019. But as per my provision of the Motor Vehicle Act, my driving license of the husband of the prisoner was effective. That section 14,
Driving license of.
the husband of the deceased was still effective, my lord, for period of 1 month. As per section 14 of the Motor Vehicle Act, my lord.
That's the grace period.
Grace period. That's provide that every driving license shall, notwithstanding its expire under this subsection, continue to be effective for a period of 30 days from the such expire.
Where is the order?
My lord, page
Annexure 5.
Annexure 5, page 17 to start.
Yes.
Page
What
20,
is the date of accident?
accident date, my lord, 21/4/2019. In my date sheet, one five, my lord. Expiry 2/4/2019. 21.
That is within one.
Yes, your lords.
And so section,
Within 1 month, have you applied for renewal?
I have not applied, but the grace period
Because they are-
before applied, he made an action.
That's the catch.
Yes,
But what the section said, provide that any case there where the application for the renewal of a license made more than 30 days after the date of its expiry, the driving license shall be renewed within effect from the date of its renewal. If I applied after 30 days. If I
Been applied, he would have applied or not. One doesn't know.
not applied.
Not applied. Yes.
So how could he apply?
Yes,
Yes,
In the meanwhile,
Yes,
accident
was-
yes,
yes,
yes.
yes.
That is the.
So how should the court presume that he would have applied after 1 month? He might have decided not to continue with the license. And that's the decision is based on Supreme Court's decision in case of Rambabu Tiwari.
The Rambabu case,
So how do you distinguish that case?
in that case, my lord, he stated. The Rambabu case, it is beyond any doubt of dispute that only in the event of an application for renewal of license filed within a period of 30 days for the date of expiry thereof, the same would be renewed automatically, which means that even if an accident had taken place within the aforementioned period. But the time period is there, my lord.
Now, is it your case that the policy condition is contrary to section 14 2B?
That policy.
14 2B says that after expiry of the license within 1 month, you can apply for it.
Yes.
It has happened within 20 days or something.
My lord,
What is the policy? Policy says, is the policy is contrary to the provisions?
Valid license.
Policy says only valid license.
Yes. There is
Unnecessary.
valid license. Valid license. Not having valid license. That is
You are relying on which provision?
My lord, 14, 14,
What?
14.
14, 2.
Odisha Motor Vehicle Act 1988.
14 2B.
In V Roman 2 is something else.
Your Lordship. Old book, Your Lordship.
Old.
Yes, it was omitted on 1st September 2019. This provision. It and
No, same.
I have marked, Your Lordship. Right side. Right side of the page, Your Lordship. I have marked.
One right mark.
One right mark is there.
You don't have barrack.
The new book.
New book. Your Lordship. The same was omitted on 1st September 19.
Yes, this request
Yes, Your Lordship.
issue notice. One week. 8 weeks. Yes.
Item now 4.
So item 4 is a contempt application, my lords. I am appearing for the Urban Cooperative Bank, my lords. My lords, it had been allotted a land in the CDA area. Now the High Court needed that land for the Judicial Academy. So the High Court took that land and in lieu thereof had also asked the government to allot them separate land. Now a separate lease case was also initiated, my lords. That was in the administrative side anyway, my lords. Separate lease case was initiated and there was a direction of this honorable court that at page 10, my lords, there was a direction of this honorable court whereby your lordships had directed, if your lordship kindly turns to page 10, of the contempt application, had directed the opposite party number 2 is expected to deal with the case by 31st January 2023.
Yes.
Your lordship. Thereafter, there have been 5 more dates: 27/6/2023, 13/9/23, 13/12/20. My lord,
Where is the disobedience?
my lord, the disobedience, my lord, they are not completing the lease case. I don't have a headquarters, my lord. The office is to be built up. So your lordships are
No,
directed.
where is the disobedience? Which order has been flouted?
Disobedience is of the order dated 1/12/22.
Oh, that is mere expectation.
It is
My lord,
only says that it is expected to do it. It is,
yes, true, my lord, but then it can't go on indefinitely, my lord. That
we only hope and expect that the executive to do something. If they don't do, what to do?
my lord, true,
Is
my
it a
lord.
contempt?
No, my lord.
Still, don't worry.
I talked to the council, in fact, the morning was quite tough. He said that he is process now. He said that you can pray for time, we can do it.
How much?
उसमें से 3 time because last Sunday was 3 to 9 4 weeks time.
All right.
I'd ordered extra 4 3.
So not beyond 3 weeks.
So उसमें
This is for the reason that that part of the order may just be expectation, but please come to paragraph 2.
yes. Yes, we will dealt with by 1 January.
So
Yes.
not me.
Because I
Positive.
By way of
expect
by way of last indulgence, 3 weeks further time is granted to the contemners to ensure that this court's order dated 1/12/2022 is complied with in its letter and spirit. All.
Deeply appreciated.
Item number 5.
Please, your lordship. The petitioner filed this contempt petition for non-compliance of order passed by.
All right, you don't have to argue. They will have to argue. Yes.
I filed an affidavit saying that we have approached the Honorable Supreme Court in SLP diary. Now the Honorable Supreme Court has been pleased to issue notice in the matter. So I am giving the order loss.
Oh, you should have.
Both in delay on the question of delay, so also in the merits of the case.
Yes, madam. Considering the a learned counsel representing the state contemners has brought to our notice an order dated 22/3/2024 passed in SLP passed in SLP bracketed diary number 33400/2023 to submit that this court's order, violation of which is being alleged in the present contempt application, has been challenged by the state before the Supreme Court, in which notice has been issued. First off, it is accordingly being argued that there is no deliberate violation of this court's order. First off, we find substance in the submission advanced on behalf of the state. First off, since the state has chosen to prefer appeal before the Supreme Court, which is pending and in which notices have been issued to the petitioner, we are not inclined to proceed with the contempt matter for the present. This contempt application stands disposed of accordingly. So let us wait.
Item number 6.
Item number 6, may I please, Your Lordship? May I please, Your Lordship? My Lord, compliance of order dated 22/11/2017.
Yes.
Yes, it has been listed for the further. Also, grant me time, I will obtain instructions.
What is the order?
My Lord, kindly have a glance to page number 25. So 4/2/2013 order.
Just a minute.
The OE was allowed.
Just a minute.
Yes, ma'am.
Page 25
Yes, ma'am.
is the order.
Yes, ma'am. Para 13, ma'am.
Just a minute. 13.
Yes, ma'am.
This has not been implemented.
Not been implemented.
Yes, 3 weeks time is allowed for the state to take instructions and file a reply to the present contempt application, stating as to why contempt proceeding be not initiated against the contemners and they be not punished for deliberate violation of this court's order. So the contemner shall, however, be at liberty to comply with this court's order in the meanwhile. When was the order passed?
This honorable court disposed of the writ application filed by the state milords by the order dated 6/3/2023 milords.
This is a contempt order.
No. Original order is 22/11/2017.
2017, this honorable court dismissed the writ filed by the state milords.
Right.
And the contempt milords was disposed of.
6/3/2023.
Mister, even if you now implement the order, we shall punish the contemners. Even if the order is complied with.
Yes.
It will depend on what the quantum of punishment, how fast you comply with the order.
Yes, I will see that.
But in any case, the person is going to be punished. Yes.
Item number 7.
May I please, my lord? My lord, I'm deeply apologetic for missing the notice of this honorable court, for which I couldn't participate in the WPC, out of which this writ appeal arises, Your Lordship. Because the notice was served on my old address. When the case was instituted initially, I was working.
So the order was passed behind your back.
My lord.
So you could have preferred a review application.
My lord. Your Lordship.
Counsel for the appellant, after some argument, seeks permission to withdraw this appeal with a liberty to prefer a review application seeking review of the order which is under challenge in the present appeal. Full stop. This submission has been made in the background of the contention that the appellant was not heard. The appellant had not received the notice of the writ petition, as the notice was served on an incorrect address.
His previous address.
Incorrect address?
Yeah.
Incorrect address. Full stop. Incorrect/previous address. Full stop. The appeal is accordingly disposed of as withdrawn with the liberty as sought.
Obliged.
Item number 8.
Item number 8, my lord, I prefer tomorrow, my lord.
Why, sir?
Inadvertently, I come with a wrong file, my lord.
All right.
Look,
As requested, 1 week then. 1 week.
Monday, my
As requested on behalf of the appellant, list this matter on 1 week.
lord.
Item number 9.
This type of matters, I am also appearing with my learned friend. We request some time to go through the entire issue, and if necessary, we may have to file an amendment. Lordship may grant us
Cancel some time.
some
But
time.
Today's morning, we found there is something which are required to be incorporated.
All right.
Let's say get some.
He's 1 week after.
As requested on behalf of the petitioners, list this matter. One matter. Batch. List these matters on. When do you want?
10 days after, also fix any date.
2 weeks.
Okay. I'm obliged.
Obliged.
Item number 10.
May please, my lords. Yes, in this case, my lords, the petitioner has challenged there are 2 notifications, my lords, notification dated 5/7/22 and notification dated 31/3/23, my lords.
5/7/22
by annexure 11 and notification dated 31/3/23 by annexure 12 purportedly under 168A of the CGST Act, my lords, thereby extending the outer limit for passing adjudication order under 7310 of the CGST Act. But these are the matters your lordship have also taken up on the last occasion in one of the cases of this petitioner, and also matters are now currently pending for Punjab, Haryana, Rajasthan, and also Ahmedabad, Gujarat High Court. And recently I was arguing on matter in Kolkata High Court has also dealt with this. They have admitted the matter and granted interim protection. But
the matter which is pending for order.
Minus. In our High Court also, your lordship have fixed the matter to 9th of April, minutes, permitting the state as well as central government and the council. Mr. Satpathy was appearing in the last occasion. He has taken notice for the GST Council, and for central government, your lordship has specifically mentioned order that the Deputy Solicitor General of India is requested to appear on 9th. They are yet to respond to the writ petition by filing responses. But your lordship have fixed all. I think along with that, other connected matters also directed to be listed on 9th of April. I am giving the order of your lordships and also other high courts. Only by lords have to examine that force majeure 168 power is to exercise the central government to extend the outer limitation period only when force majeure situation exists.
The first order is of which High Court?
Kolkata. High Court.
So those matters are coming on
9th of April, Milos. But only my humble prayer for lordship is let there be a direction to file counter, because central government is necessary party, so also the council. They have not responded as yet. State has given a counter in one of the matters, but we are yet to be also.
They may choose not to file counter.
Well, your lordship is correct also saying so.
The only difference is that in the connected matter, the so-called notice is under challenge.
But in the present case, the assessment order is under
So
challenge.
in one of the matters, my lords have also protected by not to take coercive action when the order was administration order also. In Swastik tribunal case.
We'll see.
Yes, ma'am.
List. How many matters are listed today?
This is only one matter, lords.
List this matter on 9th.
9th of April.
Along with
Ninth.
that connected matter, lordship. Along with that connected matter, lordship.
Along with
It's the same order, may kindly pass me, also, giving protection, my lords.
Second order.
Second order, my lords, may kindly Swastik tribunal's orders, my lords.
600.
My lords order.
Huh.
23, 2024.
Yes, sir.
Yes, 20.
333 of 2020.
My lords, my lords.
As the issue in the present case is same as involved in WPC number 633 of 2024.
633, my lord.
633 of 2024. It is directed that the opposite parties shall not initiate any coercive step against the petitioner pursuant to the impugned order of adjudication.
Annexure 7 and 8, because they have rectified under Annexure 8.
7,
7 and 8. Annexure 7 and 8.
22. What is the date? Next 7?
Date belongs order dated 30/12/23 and 4/1/2024.
23 and you order sign so without leave of this court.
Deeply obliged.
Item 11. Item number 11.
What is this about?
Well, this is regarding a realignment of road that the Adivasi, the petitioners that are Adivasi people, and there was a proposal for a four-way lane through their village. Now they say that they're trying to illegally align the road so that their livelihood, houses, and all they're going to be affected. For that, they have given the representative before the collector and the commissioner also. That representation is there. Nevertheless, my lord, I don't know. Representation is, of course, in vernacular, my lord, they have not translated. It's Annexure 3 series.
So have you filed your affidavit?
No, my lord, this is the first time it has come. Let me take notice, my lord.
File your affidavit.
Yes, ma'am.
Because they are tribals.
Tribals, yeah. Tribals within Bhubaneswar.
Yes. So we don't intend to dismiss this application for default 1.
Yes, ma'am. As a lodge.
And 2, we will not leave it to the representation of the
Place. I will file an affidavit.
discretion of the district magistrate or district.
This is
Huh?
Almost 14.
Chandaka area.
Yes, yes.
In any case, there is the restriction there for widening road and all.
Pardon me,
Because
lord?
of for the reach.
The freezing
reach
zone?
area.
The
Yes.
freezing zone. Well, I'd have to find out because whether they're the unauthorized occupants or
Falling under the reach area or not.
forest. Yeah, they're saying they're within the forest area. That also have to find out whether they have been.
File your affidavit.
8
weeks time is allowed. No one appears on behalf of the petitioners. Stop. And so it represents the state of Odisha. 8 weeks time is allowed for filing a counter affidavit. In the meanwhile, will you proceed with the all right.
I'll give instruction. My lord, but they've given a representation to the collector as well as Tahsildar and the chief secretary. So, should I ask the collector to file an affidavit? Or,
A collector.
Item number 12.
Oh, bless me.
If I may please your lordship, the last order kindly may be seen.
Dated?
Dated 21 February 2024.
Yes.
Wherein the state was directed to file an affidavit.
Yes.
No, sir. I need some more time that talk to the collector because there was a direction to transfer the land, the OSFC land in favor of the petitioner, he has requested me to make a prayer before lordship for another 2 weeks. May I pray lordship may grant me 2 weeks time because lordships.
As requested on behalf of the contemners, by way of last indulgence, the matter is adjourned to 2 weeks. Stop, it is made clear that if in the meanwhile this court's order is not complied with without any valid reason, the court shall initiate contempt proceeding against the contemners.
Much obliged.
Item number 13.
Please, your lordship. Lordship, kindly see the order dated 18/3/24. State has been directed to comply the order and file an affidavit.
Yes.
Here also lordships.
Mr. We are gathering this impression that your officials are too casual.
Yes, that's true, lords, because in spite of your lordship's order and my communication, lords, they have not responded in this case also.
Who is the contemner?
Lords, there was a direction. If your lordships.
Who is the contemner?
Opposite party number 1.
Who is opposite party number 1?
Mr. Malad, MS Avasti SIS. Opposite party number content application. Opposite party number 1, my lord.
What was the order?
Order annexure, my lord, 2, annexure 1.
Page 15.
2 months time was granted to you.
2 months time was granted to comply the law.
No, what?
That is in November 2023.
Annexure 1 is the order.
My lord.
No, what is the direction?
Operating part, my lord, page 15. Paragraph 11.
Right, 11. Oh,
Where is the order passed in the writ proceeding?
State has before and read, my lord. State has before the read. That was dismissed, my lord.
So that was dismissed. Where is the order of the tribunal?
Tribunal order they have not been.
Please come to 30 per hour. Therefore, in view of the judgment rendered by the court, the term tribunal justified directly its qualifying service. Want to comply with the same period of time.
Who has to comply with the order?
In fact, the DEO Puri is the officer who has to comply with.
DEO?
Puri Millers.
Puri.
District Education Officer Puri Millers.
Was required to comply with the order.
Because there was a direction to treat that period Millers as Millers counted towards service for the other benefits, 70 to 80.
Yes, according to you, who was required to comply with the order?
DO, my lord.
DO. And when was this order passed?
But this order, your lordship is pleased to pass on 22nd 11/2023, November 2023, Millers. And there was a direction to comply the order within 2 months, Millers.
The people will start losing faith.
Right, from this institution, that I understand, Millers.
He is fighting since when? When was the OA filed?
OA file, my lord. The order was passed in OA in 5/5/2018.
5/5. File on 2012.
So the OA was filed in 2012.
Yes.
So he has been held entitled to the benefits
In 2023, my lords.
in 23.
On 5/5/2018 by the tribunal.
Tribunal
There are
confirmed by your lordships in 2023.
2013. So he has been fighting since 2012.
12, lords.
And in respect of the benefits he was entitled to from 1980.
Because the schools were taken over, there are batch of cases, all were allowed, my lords. Not it's a single case. Similar cases have also been disposed of by the Honorable Court earlier.
The court
From 1970 to 1980.
takes serious notice of the conduct of the district education officer Puri in the background of the submission made on behalf of the state that despite communication made to him by the learned AGA, he has not responded. First off, learned AGA has is thus not in a position to inform this court as to whether this court's order dated 22/11/2023 has been complied with or not. First off, let the district education officer Puri join the online proceeding on next Monday for this court to consider initiation of contempt proceeding by framing charge of contempt against him.
Item number 14.
Contempt of court against. Education as contempt.
Pardon me, Lords.
You have implemented the commissioner cum
Sorry,
secretary.
Lords, I was in item 11.
Yes, contemplation, running page 2, madam. Dr. Biswajit Bose, district administrator.
All right.
Where is it?
Page 2 of the contemplation. OP number 3, my lords. Dr. Biswajit Bose, district education officer Puri.
Okay. Contempt number 3.
Contempt number 3. Yes.
Item 14. Sorry.
Item 11, Lordship, extremely sorry. I missed the when
You'll also have been pleased to direct the state to file an affidavit in that
all
case.
Adivasi people, my lords, before my lords.
Please let us understand. We don't know the case.
Lordship.
You are in item number 14.
Item number 11, my lords. I lost in the traffic. I was stuck up.
Yes, file an affidavit.
All right.
Lordship, whether it will come.
It will come, Mr. Counsel. We have requested the State Council to file a counter affidavit. The matter will come after 8 weeks.
Lordship, in the meantime, they are proceeding with the construction of the road wrongly aligned.
In the meantime, we are not inclined to pass an ex parte order. All right, let the affidavit come. Make a mention.
4 weeks, my lords.
8 weeks it will come.
8 weeks.
We ensure that their rights shall be protected.
Lordship,
All right.
obliged.
You can tell your clients also.
Obliged.
Item number 14.
Both 14 and 15 connected matter. If the lordship kindly come to page 14, I will deal with that. Lordship grant page 14, paragraph 9. The above facts are that we set aside the impugned order dated 7th October to the Tahsildar directed to deal with the petitioner's contention regarding correction of the record in line with the said order dated 6th April 18 WPC number 20. I will try to do it. Also grant me some time. I will say the Tahsildar to correct the same. 3 weeks time also grant so that in the meantime I will try to do it.
ROR correction. ROR correction.
ROR correction. Correction of
as requested on behalf of the contemners. List this matter on 3 weeks so as to enable him to seek instructions and inform this court about compliance of this court's order dated 7/2/2023 passed in WPC number 1202 of 2023.
Both the cases.
Both the cases. Same order?
Yes, please. Next item, same order.
No, order.
Similar order, similar order.
Both cases. Dates will be changed.
Connected case. Connected matter, similar order, loss may grant the same 3 times.
Date in petition will change.
Yeah.
Item number 15.
My lord, for non-compliance of the order under Annex 4, I am before your lordship. Your lordship may kindly turn to page 27. Page 27, para 4, last portion.
Page 27.
Yes.
Yes. What is the order?
My order is to release the financial benefit within a period of 4 months.
You are reading 27.
Yes, my lord. Para 27.
Para 27 or
Page 27.
This is 1994 of 2024.
No, my lord. 2937 of 20.
I am seeing some incorrect file.
Page 27.
Item?
Page 27.
Item 15.
1994.
Yes.
1994. Content number is 1994.
Yes.
Yes. And Annex 4. It starts from page 21. Sorry, page 24.
24.
Yes. Page 27 is the relevant portion.
That was passed in a content proceeding. Para 4.
Yes.
Part of the order is compliant, part of the order is not compliant.
And I am fighting out the litigation since 2002.
No, that is not the question. The
Yes.
question is that you are alleging disobedience of this order. Which part of the order?
My lord, last portion, your lordship may kindly see. In the above view of the matter, since the order of this court has been complied with, the contempt proceeding is hereby dropped. So far as financial benefit is concerned, it is open to the opposite party university to comply the same within a period of 4 months.
Yes, who is for the university?
My lord,
Who is for the university?
University, my lord, there is a panel of lawyers.
Issue notice. Yes.
Item 16.
My lord, recusate within
1 week.
oblates.
Item 16.
May I please your lordship? This is a second contempt, my lord. First contempt was ordered 3 months time.
Forget first contempt. What was the order?
To comply the.
What was the initial order?
My lord. Page 18, my lord.
18.
Page 8. As submitted by Mr. Das Land, AG Land Member Board of Revenue is not competent to entertain a revision under section 32 of the Act. After this court has issued a direction in WPC number 6968/17 to comply with the direction made in the said order. Hence, the impugned order Annexure 1 is not sustainable in the eye of law and is accordingly set aside. At this stage.
So paragraph 12 has not been implemented.
Not implemented.
Paragraph 12.
10, 11, 12.
12 is the direction. 12 is the direction.
Well,
12 has not been implemented.
Contempt petition was filed.
Then?
And contempt petition 3 months time extra was given, but it was not complied till today.
They filed for contempt 3 months for the time granted. Even then, they are not.
Yes.
No, so call it next week only because it's from court of laws. I can take instruction.
I requested on behalf of the estate, list this matter on 1 week so as to enable him to file, to enable him to seek instructions and file a reply to the contempt petition.
Item number 17
will be open for the contenders to ensure that this court's order dated 2/8/2022 passed in WPC number 40812 of 2021 is complied with, failing which the court shall have no other option but to take strict view of the matter. Yes.
Item 17. May I please, your lordship? Item 17, first item.
So what is the system? All contempt matters are listed before division bench.
Yes, all division bench contempts are assigned to a
This is not division bench contempt.
They are all division bench contempt matters.
Oh no, please see.
Because that there was a writ appeal thereafter, not the last matter. Honorable single judge disposed the writ appeal, and there was a writ appeal filed by the state, and against that, they filed this contempt for non-compliance. Writ appeal was dismissed.
Yes.
Item 17, the first item, I seek an adjournment, my lord.
First item should be adjourned. Second should be taken up.
Second item.
Oh.
Both the matters. Second item, I'm allowed to place.
Hmm?
Second item, I'm allowed to place.
Allowed to press.
Then I have
Item number 17. Item number
17. And I have filed one miscase to recall that stay order.
Oh. You have filed an application for vacating the order of stay. All right.
Fact is that that's the gist of the case, my lord.
So when was the stay granted?
My lord.
When was the stay granted, interim order granted?
It was granted on 12th February 2024, my lord.
12 February
2024.
2024. And when did you apply for vacating the order of stay?
My lord.
When did you apply? When did you file your IA for vacating the order of?
February. Last month I was filed.
All right. In second item.
My lord. Second matter.
WA 1752.
My lord. Just gist of the case, my lord. The Honorable Single Judge has passed the order in accordance to Government Gazette notification.
Sir, Council, we are not clear on dates.
My lord.
So let us have the dates first.
In March 2024, perhaps I have not.
Very difficult.
In March 24, I have filed.
10th March. 10th March. What is your IA number? 117?
My lord.
Are you seeking variation of the order dated 12th February 2024?
That was my lord.
Are you seeking the variation of the order of 12th February 2024?
My lord.
Constitution. So have you examined sub-article 3 of?
Yes, madam.
Then-
So you also can hear this matter on merit, it can be disposed of within 10 minutes.
You're ready?
Yes,
He's seeking, someone is seeking adjournment.
No, my lord, two matters are there. In items.
Yes, two matters are there. One is seeking adjournment.
That matter.
So far stay is concerned, stay does not exist anymore.
Yes, madam. But I know. What has happened, my lord? In the there are in the order there are two parts. One for regularization, another part for granting of pensionary benefits. So far as regularization is concerned, that matter has been decided in a separate batch of cases, and that has been confirmed before the Honorable Apex Court. In complaints to that direction, we have regularized his service. So far as regularization part is concerned, we have no grievance. And we have also granted more benefit than this order, because in this order, this Honorable single judge are directed to regularize him after 8 years. But as per our politician, we have regularization after 6 years. So far as pension part is concerned, that direction is contrary to the direction of the division bench. Already law has been settled by the division bench that one is appointed if under the scheme, subsequently regularized, that schematic period will not be taken into account for the purpose of pension. But that has been ignored in this case. That is the only short point. So far as regularization is concerned, state is not agreed. And in the meantime, that person has been regularized. Even if he has filed this case after his retirement, we have regularized him retrospectively with effect from 2014, my lord. And I will relate two judgments of my lords.
All right, yes.
My lord, that regarding pension, my lord.
So now you are not required. He is the appellant.
My lord.
He is ready.
My lord.
He wants to argue.
I am also ready.
Should we?
My lord.
Oh, you cannot argue, Mr. Counsel. He has to argue. It is his appeal.
My lord.
So will you please take your seat? Who is in the first case?
I am in the first case.
For?
Respondent, my lord.
For
both
the respondent.
Yes, madam.
And you are in the second case for the respondent. And he is the appellant in both the cases.
Yes. In first case, order of the second case has been relied upon, that has been disposed of. So if your lordship will decide second case, that will cover their case also.
All right.
I am seeking adjournment because my lord, Justice Mishra was argued that matter.
All right.
So that I seeking that.
Okay. All right. Let's this matter on. List these matters before a bench of which one of us so and so is not a member.
Where I have argued? Supreme Court.
No, here. Annexer 1. It's 20.
Yes.
Yes,
item number 18.
my lords.
Item 18 is to be taken up with along with item 38, ma'am. It was also the last time, ma'am, directed to that not charge regularly. Item 38 today, ma'am, will take up. Item 18 is to be taken up along with that.
Very well, my lord. My only respectful prayer is that the facts of 38 and this case are very different. And why I say this, my lord,
So facts may be different, but whether the issue
is also, my lord, concluded by the Supreme Court already. Now we are seeking the.
So it has nothing to do with 38.
I am deeply obliged. Whatever.
Can we take up your matter after 38?
Very well, my lord. As your lordship pleases, my lord. I have another small prayer, my lord. There were these batch of OAs, my lord, 5 which were filed, which relates to this very employees union. The state has already filed writ appeals against those.
Union.
My lord, the respondent here is a union, my lord.
This is a service matter.
Yes, my lord.
Service matter of government.
No, my lord. This is relating to work charge employees in major irrigation project, my lord, of the Samal Barrage. And this has been, my lord,
But how union is a labor industrial dispute?
No, my lord. These were holders of civil posts. They, in their representative capacity, have formed a union, my lord. Not in terms of the Industrial Dispute Act, my lord.
Union cannot. All right, we will see.
Very well. May I provide that other number also, which is the writ appeal against the main matter?
Make it.
My lord, obliged.
Next, we will pass order on later.
Item 19.
Before going, yes. Yes, no problem.
Yes.
It is covered by division and so on.
It is covered. Covered.
It is to be considered as per old rule.
Item 20.
The state seeks to achieve the judgment in the claim on 23 at Electoral Court. That's 1972. To summarize the entire case, if the person was granted an appointment to the rehabilitation assistance scheme against a group D. After availing that appointment, he came to the Honorable Court seeking group C. That's what happened. This is under challenge before the Honorable. But before that, I must complete to my notice that there is a hearing. So, my lord, kindly note.
Lord, I am appearing for the sole opposite party.
So, what is the delay?
Delay is 360. 3 days.
Where is your application?
Do you have any
393 days delay, my lord. They have indicated, if your lordship will consider this aspect, my lord, I am ready for argument, my lord, so far as delay part is concerned.
So delay we should condone.
But your lordship kindly hear me for few minutes, my lord. There.
On what?
My lord, because I have.
Mr. Counsel, you are not the appellant.
Let them to. Let them.
Let us deal with them first.
My lord. Obliged.
Yes. So what about the delay?
Sir,
Very difficult.
Sir, dismissed petitions of more than 200 days. So I must also bring it to my.
But you should be, your department should be careful in future.
You have to give sufficient cause. What have you given? Nothing. Para 4, come to para 4 of your application. Just nothing.
Dismissed. The IA number so and so is the present writ appeal is time barred. This application has been filed for condonation of delay of 393 days.
Yes.
Stop. Following is the only explanation given in the present application seeking condonation of delay.
Paragraph 4 of that delay condonation petition, that file was moved from one place to another.
That's it.
Full stop. We are not satisfied with the explanation so furnished for condonation of delay. So this application is accordingly dismissed. Next, WA number so and so. The limitation petition having been dismissed, comma, consequently, this appeal also stands dismissed. Yes.
Item number 21.
Order of the appellate authority, my lord, has been passed by the Honorable Single Judge. The fact of the case, my lord, I may permitted to submit the fact.
Where is the order first?
Yes, my lord. Yeah, at page, my lord. At
41.
41 is order. The operative person is, my lord, at page 47, your lordship.
Yes.
May I read the para 8 of the operative person?
So what was your age?
My lord, at the time of my appointment, the age was 41, my lord.
Age is 41. And what is the maximum age?
So for the provision in the Private Education Act and rule, there is no upper age limit. Your lordship may kindly come to the Orissa Education Act.
No, this is your submission that there is no upper age limit.
As per the provision in the Act and rule.
Right. So where is that in the why the learned single judge? On what basis learned single judge has observed that you are overage?
Yes, I have submitted it for the learned single judge, Millard, that as per the managing committee, by condoning my overage, given me appointment, as because there is.
Mr. Counsel, when there was no age limit prescribed, where was the question of condoning the age limit?
There is no overage, Millard.
It was condoned by the managing committee.
Yes, Millard.
So the very fact that the managing committee condoned the requirement of maximum age means that there was some maximum age prescribed. This is so simple statement which we are making.
At the time of appointment, pardon, Millard, at the time of appointment, the question of age does not arise at the time of it. Kindly have a glance to the Act of the Education Act. Section.
What is the age prescribed? What is the maximum age?
32.
No, this is correct. Only in that regard, I will submit to this honorable court. In the Education Act for appointment of this, there is no age limit prescribed. Is correct in that.
Then this finding is wrong then.
No, to that extent, he is correct.
No, all right. To that extent, he is correct that the rules and the Act do not provide upper age limit.
Yes.
So where from the idea came in the order of the learned single judge that he was overaged?
Upper age limit is 32 years and opposite party was appointed at the age of 41. That's the finding.
The normal, because in the absence of any provision, the view of the honorable court was the conditions governing the civil post style. Yeah.
Let affidavit. You should not. You are appearing.
No.
Yes, please. Please address.
The fact of the case, Millard, that by virtue of an advertisement, I was given appointment in a college, in a school, private institution. At that time, my age was 41.
So where is the advertisement?
But that was not that is the local notice board, local school board, and there was no age limit, Millard. Only BA bid was the qualification.
Where is that advertisement?
I have not annexed that advertisement, not me, Millard.
So did you mention in your writ petition that in the advertisement no upper age limit was prescribed?
No, I have not mentioned.
All right. So where is the order passed by the governing body relaxing the age limit?
That was no age limit was there.
No age limit was there. We accept your contention, but you made this submission just now that that requirement was relaxed.
And so the government, so far the government age, government service, government age.
Please be kind to us. We have put a question that according to you, there is decision of the governing body whereby your age was the requirement of upper age limit was relaxed. Did you make this submission right now?
Yes.
Where is that decision?
That decision is with not. No.
Then on what basis did you make this submission?
I got appointed.
You made this submission that requirement was relaxed. Just now you said this.
Pardon me.
So where is that?
That was the advertisement was not with me.
Page 45, 106.1.
I understand.
Yes. Yes. Please.
If I understand it, because when on the court posed the question, how could you be appointed at the age of 41? Then probably the petitioner answered that managing committee condoning my appointed. So that was my duty. That has been taken. Probably, because I have to verify the petition.
But the 11th single judge relied upon Rule 52 of Orissa Service Code.
Yes, that's what I was coming. Because in the absence of any rule in the Orissa Education Act, next to all of it was the view of the interest to that these provisions are done. That might not be it.
You prescribe retirement age.
Yes, retirement age.
60. No, till date it has not been taken up.
It's not aided.
No, it
It's a private.
purely private.
Private
You
Private
don't
is,
provide any aid then.
no.
Government is not.
No.
Till date, government.
Management.
So in the absence of
No, I can appear.
and who are they? Baman Charan Mohanty?
I am the appellant, my lord.
No.
Baban Charan Mohanty is the appellant.
Now
I can appeal for 1, 2, 3. Except the phone.
you are for state. Who is appearing for management committee? Notices to go.
Notice has to go.
Yes, so notice for the part number 4. Informs or accepts notice on behalf of 1, 2, and 3. Requisites 1 week.
Oh, within 1 week. Within 2 to 3 days.
1 week.
15 days delay, my lord.
Issue notice. Limitation and main matter.
Item 22.
Notice?
I would issue notice on delay.
No, both.
Delay condone?
No, we cannot condone delay in the absence of the other side. Had it been 1 day or 2 days, the matter would have been different.
Item number 22.
Yes. PIL.
Yeah, it's a PIL, my lord, against serious allegations of corruption against State Animal Welfare Board, my lord. It is under the Fisheries and Animal Resource Development Department, my lord. And there, your lordship will see para 4.4. That is.
They want to withdraw.
Want to withdraw?
Yes. So some development must have taken place in the meanwhile.
These matters should be
We have issued notice already?
No, no, my lord. Today is the first time it has been.
Not so, not
The first time.
All right.
But there is a judgment, once in the PIL, the notice is issued, the court sees of the matter, then the PIL petitioner turn back and says that I'll withdraw, it is not allowed.
It's not allowed, my lord. With a lot of compensation has also been imposed on this.
Sheila Barse's judgment.
Yeah.
Sheila Barse's judgment.
Sheila Barse.
But that judgment he must be knowing.
No, the Sheila Barse judgment.
Land council must be knowing the judgment and therefore before notice.
Permanent Katara.
Only thing is, my lord, this is my submission subject to your lordship's acceptance. This kind of matter should be referred to the Lukayut, my lord, because they have an enquiry wing which operates and extensive enquiry can be. But your lordship
That
can
can
issue
be done
notices.
in appropriate cases.
The serious allegations are there, in fact, my lord. Serious allegations are there, but
Next.
lordship is putting it to another day.
No. We have withdrawn.
Yes.
This
And a
is-
letter for withdrawing.
Okay.
Item 23.
Yes, state.
23.
Contempt.
Notice was issued. 6/3/24. Notice was issued.
There is no representation on behalf of the petitioner. It appears from the office note that the petitioner did not even file the requisites for issuance of notice in the light of this court's order dated 6/3/2024. So this contempt petition stands dismissed for default.
For admission, item 24.
Item 24, today I have received a copy of the counter filed by the state. I would need at least 2 weeks' time for my response, rejoinder.
Can we know, Mr. Senior Counsel, this is Rao? Mr. Rao. Mr. Rao, that why this matter has remained pending for 23 years?
Your lordship will remember on the last occasion when your lordships have given a lengthy order saying that when your lordships have given a lengthy order saying that the government should be responsible for the contempt for not complying the directions of this honorable court, then only everything came out. What has happened? There was an acquisition of my land, and I have filed a writ petition saying that since my plot has been acquired, give me a similar plot elsewhere. And when the matter was going on, then the government came up with a plea that the development authority for whose benefit the land was acquired, they have taken a plea saying that we don't require the land any longer and we want to surrender it. Then this honorable court directed them to make an inquiry, to have a spot visit, and thereafter find out if the land is available, all those things. They took long time in making those inquiries. Thereafter, now they have come up with a plea saying that land was acquired and it was fully utilized. Additionally, they say that my vendor from whom I have purchased the land
he has also taken away the compensation money. So if that is the case, if the compensation has already been paid, throughout for the past 20 years, they have been taking a plea that land is not required, all those things. That comes to a different turn now. So let me take instructions from my client. Today they have filed the counter. So,
as requested on behalf of the petitioner, list this matter on when?
2 weeks.
2 weeks. So as to enable land council to consider filing of a rejoinder to the counter affidavit which has been filed on behalf of the estate.
Item number 25.
But there are how many writ petitions? How many? 3, 4. 3, 4 petitions.
That lead item is Abhayjana, lead item.
Item 25.
75.
I've been for the opposite party workmen. 17 will have been complied.
Yes.
The lordship calls for the LCR last occasion.
Please to call for the LCR from the you will put records from the outside it not. Document order dated 12th of March.
The reports have come.
No.
Xerox copy.
Yes. So have you seen?
No, my lord.
Are you required to see?
Required
You want? Huh?
We require some time.
Because here only question is because I am questioning the order on the ground that the labor court set aside the termination order on the ground that 25 days has not been complied with. Our plea was that he was not a regular employee. He was a employee who was employed for whenever there was work was available. But they say that he was worked for 240 days within 1 year. That is why 25 days is bound to be complied with. In the alternative, my prayer is that in the Honorable Supreme Court direction, but if 25 years has not been complied, then he is entitled to compensation, not for reinstatement. That is all. If the lordship please that he is to get compensation, lordship can decide that their trial court has.
We will take up the matter tomorrow. Tomorrow we will take up.
Your lordship.
So as to enable land counsel for the petitioner to peruse the original records received from the Industrial Dispute Tribunal. List this matter tomorrow.
Item 26.
Obligation.
Item 26 is a passover.
Sir. Why? This
That's
is 12-year-old matter.
Counter not yet received matter. In this case, counter not yet received matter.
So all the facts certainly on its petition stand admitted. Since they have not filed any counter affidavit, you are for the petitioner.
Yes, ma'am.
Then you should be happy about it.
My senior will argue in this.
It's a different matter. We find it very difficult to adjourn 2012 matters.
Only passover matter.
Like that. By way of indulgence. You have not filed any counter affidavit. Who has not filed? Mr. Panigrahi, advocate for OP number 1. Who is OP number 1? neither counter affidavit has been filed on behalf of OP number 1, nor there is any representation on who is the OP number 1 on his behalf. First off, learned counsel for the petitioner seeks adjournment. Shall place this matter tomorrow.
Affidavit. Now they require some time to file
Other
either
reply.
reply.
All right. Who are you?
I am IDCO.
Huh?
IDCO, my lord.
OP number 2.
Who is the petitioner?
I am for the petition.
And you are the respondent.
My lord.
Is there any system? This matter on 1 week.
Item number 28.
Interim order to continue.
Interim order shall continue in the meanwhile.
Make your learning.
No, I'll follow. Otherwise, it's very difficult. Since they are respondents.
The petitioner may be permitted to withdraw the same. I am filing a memo for withdrawal of the writ petition.
Okay.
Your lordship may pass on application.
Please. Counsel for the petitioner seeks permission to withdraw this writ application. This application is accordingly dismissed as withdrawn. Memo taken on record.
Item 29.
Pursuant to your lordship's direction, the secondary director of secondary education Odisha issued notice to the secretary of managing committee yesterday. He appeared, my lord, but order has been passed by the director has not yet been communicated.
Order has been passed. File on affidavits. As requested on behalf of the state, this matter on 1 week so as to enable him to file, to bring on record an order which has been passed by the secondary education on 22nd April 2024. 22nd March.
April. Yesterday.
Second by way of an affidavit. All right, 2 weeks.
Item number 30.
I please, lordship. This is a matter, this batch of matters. Your lordship heard this matter in extenso. Of course, my lord Justice Mishra was not there. My lord Justice Raman had given a date chart to your lordship, sir. I've also prepared all that must be available in the file. This is
Can we take up the matter on say Thursday?
Next week, any date? You also pick next
Monday.
week.
Monday.
Next Monday. Monday.
Monday at 2 p.m. we can take up.
About 2 p.m. Yes.
Monday 2 p.m. Another matter. Tuesday next. Tuesday.
Tuesday.
Tuesday at 2 p.m.
Well, the date chart I've given, I can take it back and I can submit it.
It's there. Date chart is here. Understand?
It is there.
Item 31.
My lord, I'm amicus curiae. I'm suffering a little.
What happened?
I'm suffering.
Then why have you come? All right.
10 days time may be given.
10 days, all right. Suffering, then you should not have come. Just inform. As requested on behalf of, you are the petitioner.
Amicus curiae.
Petitioner.
Amicus.
Amicus. All right. List this matter on. When do you want?
10 days time.
2 weeks. Is there any urgency?
No.
Item number 32.
Item number 32, my lord. This is the matter relating to payment of SDSA compensation to the petitioners who are the legal heirs of the deceased bank employee. There is a scheme of the bank, and as per the scheme provision, the petitions are entitled to SDSA cash compensation. And in the matter, delay has been condoned, and copy of the appeal memo has already been served on the council for the bank.
The letter, last time delay has been condoned, my lord. Let a copy of the appeal memo may be served on me or notice may go, whatever you lord.
You may receive by notice. Let us see what are the merit. Where is the order?
Yes, ma'am. The order is that Annexure 6, my lord.
Yes.
Page 17, my lord. I have also filed the certified copy of the order subsequently. And the order dated 3/3/2020. Had redeemed Mr. Lorna Council for the petition SK De Lorna Council.
This is a compassionate appointment matter.
Ma'am?
Compassionate appointment matter.
Yes, ma'am, but this is, I have a two-fold of prayer. One is compensatory appointment, other one is SDSA compensation. But the bank found me as eligible for getting the SDSA compensation. They have issued a letter under Annexure 2 that they have stated that I am eligible to get the SDSA compensation and I have to submit an application before the bank. And your lordship kindly see Annexure 2. Annexure 2 at page 11.
How can you challenge this order? Annexure 6.
Yes, Annexure 6, my prayer is in two-fold prayer, my lord. That is, one is compensation amount. I am not claiming compensation appointment. I am claiming only SDSA compensation amount that bank has assured me to provide.
So the bank will, if the bank has assured you, then bank will give you.
Well, but they're not giving, my lord.
Then there is no merit in this application.
Well, the bank is not providing because despite my submission of the necessary application to the bank as per direction of the Lorna single judge, my lord.
This is the writ appeal you are assailing in order.
Yes.
You are not agreed by that order. Just see the order, page 17. You say that you are not agreed. And your grievance is something else. That is a different cause of action.
Well, in the writ petition, I have prayed for payment of SDSA compensation and compensation appointment. But so far as the SDSA compensation part is concerned, my lord, that has not been taken into consideration by the Lorna single judge.
Where is your writ petition?
Mr. Counsel, according to your own submission, the bank is ready. Bank has in principle decided to give you ex gratia. Then how can you assail that order?
Lord, in 2005, we communicated him. He did not respond, my lord. And that fact was suppressed in the writ petition. And I specifically
then pay.
It was in 2005, my lord.
Ex gratia can be paid.
Your lordship may kindly see our counter affidavit. The writ petition at page 4, at paragraph 4, my lord.
What is that?
In the writ petition, the facts of communication made by the OP1 to the petitioner dated 8/9/5 requiring them to submit fresh application for ex gratia with all details within 15 days referring to the petitioner's application.
So whether you are ready to pay or not.
So that I have to take instruction.
You were ready.
Ready.
You're ready in 2005, my lord.
Now you are not ready.
That we have to take instruction, my lord.
Difficult.
This is a policy decision, we have to take
The
instruction.
question of policy decision. List this matter on 2 weeks for London Council for the bank to inform this court as to whether the bank intends to pay the ex gratia amount or not.
This was also not assailed in the writ petition, my lord. Because nothing was said about this.
All right. Sir, we are sitting in High Court. These are small matters.
I'll take instruction.
So you should come in the next week and tell the court that yes, the matter has been resolved. He was entitled for 5 lakhs. We have given him 6 lakhs.
I'll take it. But some time may be granted.
1 week.
No, not 1 week, a little more
1
than
week.
that. I have to
2 weeks or 2 weeks.
3 weeks, my lord. Time.
3 weeks.
Item number 33.
33, Your Lordship, I was praying some other day. Mr. Palit has suffered a bereavement in his family.
No. When do you want?
My lord, any day, not today, just not today.
I will, as jointly requested on behalf of the parties, list this matter on 1 week.
Item 34.
Obliged.
34, the affidavit has been filed by the state. I want to give a reply. But ready also give me some time so that it can be filed.
It is stated by London Senior Counsel appearing on behalf of the appellant.
Yes, respondent. They are applied, we are from respondent.
No, you are for the
Respondent.
respondent.
Private respondent.
That a reply is required to the affidavit filed on behalf of the estate in this matter. So, for this said purpose, the matter is adjourned to
2 weeks time.
2 weeks.
Nice.
Item number 35.
May I please, Your Lord? It's a batch of writ appeals.
So from Monday, I intend to do this arrangement. Where the council who is to begin will sit and stand. Because it is very difficult for us to identify.
What can happen is, we can go to the second row.
Exactly.
And just like in the Honorable Supreme Court, only whoever is asking.
Delhi High Court also. So petitioners this side, respondent this side. So there is no confusion.
My lord, in 15 days time, your lordships will say, Odisha High Court, this is the practice. Not Delhi High Court.
20 years back, we had only 2 councils on behalf of the state. Now 60, 70. So naturally, they require more space.
My lord, Mr. in lighter vein, my lords. My learned senior was a government lawyer for a long time. And he is always telling me that we used to do 70 cases a day. And we had spoiled these youngsters.
Yes.
Well, a batch of writ appeals filed. The short case is that it relates to regulation of laboratory technicians. Well, input order is at page 46, annexure 5.
Annexure
5, my lord. Page 46.
Yes.
Well, all the cases, my lord, there is an application for condonation of a delay.
because they have filed 8 months after. That is up to.
The first case is Akhil Kumar Naik. Lordship, that was filed on 12/5/2022. This is the leading case. If your Lordship will decide this, all the matters will be decided.
Which item?
My first item, well, that is WA number 687 of 2022.
All right.
The order was passed on 11/12/2021. So, my lord, in view of Honorable Supreme Court's judgment, my lord, that COVID period that we have filed it on 12/5/2022, that is within that limitation period.
No, the 6 months.
Perhaps my senior. This. Your Lordship, let me. Order was passed on 11/12/2021. Honorable Single Judge Order. 11/12/2021.
Yes.
This writ appeal was filed on 12/5/2022.
Five months after.
Well, in view of the judgment of the Honorable Supreme Court, my lord, that COVID period, it starts 90 days from 28/2/2022. It is up to 1/6/2022. So it is within the limitation period of 12/5/2022. There is no limitation.
Yes. So this is your submission on limitation.
Yes, ma'am.
In 687.
Yes, this is the leading case.
Just. Who is appearing in 687 for other side?
Mellot.
He is right.
Mellot, yes, is filed in the month of May. But your Lordship, the COVID period is 28/2/2022.
No, in the light of Supreme Court's decision, this period has to be excluded up to 1/6/2022.
Yes, ma'am.
But my lord, in view of the section 6 of the Limitation Act, my lord, once the period was over, then the time is run after, because they have to file immediately after.
When was the Limitation Act enacted? After COVID period or before? Before that. So after and during the COVID period, some order was passed by Supreme Court, taking into account the provisions of the Limitation Act.
Well,
so we will have to follow that.
well,
So motto, yes.
Yes.
What is your IA number?
Like that. Because there is no limitation.
So no limitation.
Yes, ma'am.
No, we have not filed IA.
So, ma'am.
Against an order dated order of the learned single judge dated 11/12/2021. Other, we can mention that it is not barred by limitation in view of the Supreme Court decision that was the appeals. The appeal 687 is not barred by limitation.
Well,
all right. Let us begin.
So in my cases, I have 10 cases. In those cases, delay is more than 1 year.
This order we have passed in 687. This order which we have passed.
For the first time, my 9 cases have been listed today. But in those cases, delay is more than 700.
We have not passed any order in your case.
Fine.
We have passed this order in 687. All right.
Fine.
So after 687, we decide after 687, we will take up your matters also. So if there is any question of law involved in which you also want to address because you are parties in the other cases, we will hear you on merits. On the point of limitation you want to argue, we will hear you on the point of limitation. So it is not that this order has been passed and will apply in all the cases. This much basic we also understand. Yes.
May I submit, madam? Lordship, the input order starts at page 46. I'll draw my lord's notice to page 85. It starts from paragraph 14.
85.
My lord.
Yes. Paragraph
14, my lord.
14.
1-4.
Yes.
1-4.
Yes.
May I read, my lord? As per Rule 4A1 of 2019 rules, which is extracted above on the date of commencement of these rules, all the contractual laboratory technicians who have been duly recruited by the concerned society schemes and have completed 6 years of satisfactory contractual service shall be deemed to be regular government employed as one-time measure subject to fulfillment of eligibility criteria as prescribed under Rule 5. Rule 5, which deals with the modalities for induction of laboratory technician to the cadre, in Sub-Rule 1 stipulates that such laboratory technicians should have the minimum educational qualification and other eligibility criteria as per Rule 9 at the time of engagement under society/scheme. Rules 9 prescribe the eligibility criteria for direct recruitment. Under Sub-Rule 5 thereof, which deals with the minimum educational qualification, it is provided that educational qualification of the candidate for the post of laboratory technician shall be as specified.
Where is that rule?
Yes, sir. May I submit a copy? I have prepared a memorandum. So all the rules, the executive instructions, all these are in the for my Lord's convenience. I have
Where is 2019 rule?
Yes, my lord. That is at page 14.
14.
Maybe.
Yes.
But in that rule
4, 5, and 9.
Well,
just a minute. Yes.
May I read my rule? 4, my lord.
4.
My
We have read.
On the date of commencement of these rules, all the contractual laboratory technicians.
We have read.
My lord. Well, your lordship has seen that Rule 9 also. Why I am saying that Rule 9?
Yes.
Rule 9 B, your lordship may see.
Yes.
That is the minimum educational qualification.
Rule 9.
B, my lord.
B. Yes. 5.
My lord. Sorry, my lord. The educational qualification of the candidate for the post of laboratory technician shall be as specified at column 4 of the appendix.
Yes.
Your lordship may see appendix at page 20.
Yes.
That most of first science examination under Council of Higher Secondary equivalent part diploma in medical technology and medical college hospital of the state, any other private, that is important. Any other private institutions recognized by the government of Odisha of All India Council of Technical Education.
Yeah.
Why I am showing this one? If one is to be inducted, he must have that minimum educational qualification.
Yes.
So you will have to see this
Yes.
qualification at the time of induction or after induction, after completion of.
At the time of induction, in order to be eligible for induction, he must have that eligible
But
criteria.
in this case, you have inducted them, they continue for 6 years. At the time of regularization, you raise all these questions.
No, we have not inducted them. They were appointed under society. We have not inducted them. They are appointed under a society, and that
society means that the scheme.
Under the scheme, because there are no provision for regularization of them. This rule was come into force in 2019. As per the rule, that rule was framed that those who have the requisite qualification, even if appointed under the scheme or under the society, they will be inducted to the regular court. This is the rule.
Come to rule 5. 5.1. Health laboratory technician
who have the minimum educational qualification other as
eligible criteria as per rule 9.
So according to you, 4 is subject to 5 and 5 is subject to 9.
Yes.
And 9 accordance with appendix.
Yes.
That is the submission.
Yes, that I am to submit.
According to you, further, this scheme relates to the appointment of
laboratory technicians.
Laboratory technician in the medical institutions of the state, not private institutions.
No, my lord, which were taken. No, not private. For state, under state government, my.
So this deals with contractual laboratory assistants.
Yes, ma'am. Those who are continuing under different schemes and in the society. So, in order to bring them to the fold of the government, this rule, this is one-time measure. Those who have that minimum requisite qualification, and the Honorable Single Judge has held that since they have the requisite qualification, they are to be inducted in accordance with Rule 4 and 5. Our case is that if they have the requisite qualification, we don't have a case. If they don't have the requisite qualification, the finding of Honorable Single Judge is wrong. So, what was the first circular issued by?
So what was their grievance?
That was the grievance. They have the requisite qualification, saying that they have prosecuted their studies under private unrecognized institutions. The Honorable, that requirement is that they must have passed from a
When was the writ petition filed?
In 2019.
2019 writ petition was filed.
So I'll bring my lord's notice to that writ
Yes, please, please.
Well, I'm reading paragraph 2. Taking into consider the above aspect, government have been free to say that the vacancies in respect of laboratory and candidates who have passed out from recognized private institutions and have registered their name in the respective boards, provided no part from government are available. In case there is available of candidate from both government medical colleges and private institutions, then first priority should be given to those candidates who passed out from government colleges. If there is still any vacancy, the remainder vacancies may be filled up from candidates passed from the private institutions. Then this was modified in 2007 at next page at page 2.
Yes.
Page 2 of that memorandum, my lord. Because all the circulars I have given it, so for my lord's convenience. At page 1 is the first. The notification dated 5/10/2006. My earlier, it was the stipulation those who have passed from the 3 government medical colleges, they are only eligible for appointment as laboratory technicians. Since number of candidates were not available, that stipulation was relaxed on 5/10/2006.
Whether this rule was challenged or not.
No, my lord, that rule is not under that I am submitting. That rule is not under challenge. They want to say they want to be inducted in accordance with rule 4 and 5. But my submission before my lord, if they want to be inducted in accordance with rule 4 and 5, they have to qualify as per the qualification prescribed under rule 9B. If they don't have that requisite qualification, they will not come under rule 4 and 5. But Honorable Single Judge has held that they have the requisite qualification. So I want to show my lords, they don't have that requisite qualification. If they have the requisite qualification, the state has no case.
What is the requisite qualification?
That I have shown, my lord, that they must have passed from a private, even if that
AICT recognized the qualification.
Even not, my lord, AICT, I am not saying not AICT recognized. They must have, as per the rule, they must have passed from a private recognized college. Again, I am reading that what is the requisite qualification I am reading well.
What is the qualification of this respondent?
From private colleges not recognized by the state government.
But again, facts.
Yes. That made it, my lord, that what are the, my lords asked me, what are the, any other private institution recognized the government of Odisha or All India Council of Technical Education, to either government of Odisha or All India Technical Council of India. Sorry, All India Council of Technical Education. AICT. This is the minimum requirement. I'll draw my lord's notice then to the writ petition filed by the petitioner. Sorry, respondent. Well, you also got it.
Where is the writ petition?
Writ petition that must be with my lords, that we are not annexed.
Supplementary.
That writ petition 33301 of 2020, my lord.
Yes.
It must be scanned, my lord.
Yes.
That's we got it.
Which paragraph?
Right.
Which paragraph?
I am not showing that what I am saying about page 16 of that writ petition.
Yes.
Sorry, my lord, page 17.
Institute of Medical Technology.
Page 17, my lord. You know, this is the certificate.
Diploma in Medical Lab.
Page
17, my lord. And if this certificate satisfy the requirement under Rule 9B, then they have a case. If it does not satisfy, then they don't have a case.
And what is the meaning of this registered by government of Odisha?
My lord, you also may see, I don't understand
What is 19, page 19, come to page 19.
Page 19,
Institute of Public Health and Hygiene.
Recognized and approved by central and several state governments.
Faith certificates.
Is this page 19 is recognized by AICT?
No. This is the institution, they have named it, the institute's name is Institute of Public Health and Hygiene.
So on what reasoning these qualifications have been had to be valid qualification?
It must have passed from a private recognized.
No, what is the reasoning assigned by learned single judge?
Honorable single judge has held that they have that requisite qualification.
On what ground?
The ground.
They must have some reasoning must have been assigned.
Yes, the ground is that they have passed from that private institution. So that is a, so far as honorable single judge has held that since AICT approval, the private institution which has been approved by AICT, that is the stipulation, that is not the only stipulation. That was the or. Two stipulation, either or.
No, let us see the reasoning.
Yes, ma'am. Para 19. Yes, ma'am, that I am showing that page. You will also have seen that page 85 at para 14. You will also turn to page 85 para 15.
Come to paragraph 19.
Well,
page 46.
Before that, I am coming. Sorry. Yes, ma'am. Honorable single judge has held that has been recognized by the state government.
On what basis? There is no basis. All right.
This is the
that is the only question.
Yes, ma'am. That is the only question. If they have the requisite qualification, as per the rule, they are to be inducted in accordance with Rule 4 and 5.
All right. So that is the only question?
That is the only question, ma'am.
Don't be on facts. You have to satisfy your qualification is recognized by either the government of Orissa or AICT.
My lord, I would like to draw your lordship's attention to Annexure 9, page 52, your lordship may see.
Annexure 9 of?
Of the read petition.
Annexure 9.
There.
Lord, the actual position your lordship wanted to know what is the basis and what was the direction. They have not stated, my lord.
No, forget. Now the ball is in your court to satisfy that the qualification which you had was recognized by the state government or AICT. This is a simple question.
This is the simple. Yes. Prior to that, your lordship, 52, your lordship got it, my lord.
Yes.
My lord, since in the year 2005, my lord, that has this circular has not been shown to your lordship. In the year 2005, my lord, only 3 government approved medical college in the state, and out of which 30 students pass out in the DMLT course. So when the shortage of for 92 posts of the laboratory technician is required to be filled up, the state government wrote letter to the Director General TB that criteria for relaxation that we have not having any AICT approved or the government recognized, because there is no such a government recognized private educational institution in India, in Odisha, up to 2014, my lord. So when the Director of Health Services wrote letter to the Director General TB CTD New Delhi, criteria for selection, by mentioning all these facts and the criteria, the qualification, the government of India has, your lordship may see Annexure 10, page 54. In reply, they wrote a letter to the government that you may fill up with the non-government and the non-ICT approved student subject to the
We have
working.
understood. So we are putting another question.
My lord.
Because of dearth of qualifying persons, a policy decision was taken that even those who are not qualified, who do not have the qualification of recognized institutions by the Odisha or AICT, even their services can be taken on contractual basis.
My lord.
All right.
My lord.
So this was the decision.
My lord.
So despite the fact that your qualification was not approved, was not recognized by the Odisha government, and nor by the AICT, your services were taken.
Taken by way of a transparent by recruiting process, advertisement, everything
process, despite the fact that you did not have that qualification recognized by the government or recognized by the AICT. So therefore, this position is admitted that on the date of your contractual appointment, you did not have these qualifications.
My lord.
All right. Is that admitted fact?
My lord.
You continued for 6 years.
Not only 6 years, for more than
20
years, my lord.
All right, 20 years, 25 years.
My lord.
Did you acquire this qualification recognized by the Odisha government? No.
My lord.
All right.
Para 12 of a writ petition, you have said so. What is the reply to Para 12 in the council?
My lord.
Para 12, whatever it is, we have inherited everything in Para 12. The Para 12 of a writ petition. What have you said?
Counter affidavit.
How have you replied to Para 12 of the writ petition in your counter?
At my Para 13 of my counter, my lord.
Yes. Let us see the form. Para 13.
My lord. My internal page 7 of my counter.
Not really clear. No, they have admitted that they are not recognized. If not recognized, then how can you rely on on the rules?
My lord, I am just your lordship. Identical issue was already relating to the regulation of such non-recognized non-IHT was some of the candidates has approached before the learned Odisha Administrative Tribunal in OA 4179C of 2014. In a batch of cases, the same issue was involved. They have stated that the tribunal has held that since you have at the time of you have
after 2019 rules.
Yes, my lord.
Just a minute. That was after 2019 rules.
No, my lord.
Then
the same issue, my lord, and they have gone to Honorable Apex Court and they have lost and they have implemented.
Mr. Counsel, please try to understand what we are asking. Your claim is under 2019. So your claim will have to be dealt with in accordance with 2019. Till 2019 rules are there, we have to follow. We follow law, whatever is laid down.
My lord.
So we have to follow 2019.
My lord.
So whether the Odisha, there are two aspects.
My lord.
The this administrative tribunal bench decision is not binding on the High Court.
No.
And two, we have to follow what is there in 2019. That was before 2019.
The main aspect has not that is why the Honorable Single Judge has held that since they have utilized and everything they have used, so as per the Rule 20 of the relaxation provision of the Rule 219,
all right,
you dealt with that and by taking
just a minute.
Your Lordship,
where is that? Where is that relaxation?
That part has not been.
Just a minute. Where is that relaxation?
Judgment.
Page 20 of my memorandum, Your Lordship. Page 20 of my memorandum.
Yes.
That relaxation.
Yes, so relaxation is the only thing.
That is the judgment also, my lord, because in the case of
So the judgment, the government will relax, the High Court cannot relax.
No, my lord, by discussing, because my lord, your lordship knows the 1990 Supreme Court in Bhagavad Prasad, my lord, see, the similar issue, their lordships of Honorable Apex Court held, since the persons have continued for a pretty long period, so mere technicality that they have don't, the qualification, the experience itself says that
We have prima facie, we have doubts about these institutions, whether they are fake or not. We can order an inquiry into that also. So before taking into any exercise of relaxation, we may request the state government to do that also. What is this? In the certificate, it is mentioned that recognized by state government of Odisha and various other state governments. Is this the way the certificates are issued?
That is why
these institutions prima facie appear to be fake. This is our tentative view.
Rule 20, by invoking Rule 20.
See, we are prima facie satisfied that under the rules, since your certificates granted by the institutions, those institutions were not recognized by the ICT or the state of Odisha, you cannot take advantage of these rules. All right. The only thing which can come in your aid is the relaxation part. That relaxation part will have to be looked into by the state government and in no case by the court. The Supreme Court may issue such direction. The High Court will follow the law as it is there in the rules. All right. So be clear. And when we request, if we request, we don't know. If we request the government to consider relaxation part, we will also request, in view of the nature of certificates which we have seen, to see whether these institutions, merely because you continued because there were no hands, you were engaged in a scheme, you were engaged on contractual basis.
And
your right will flow in a contract.
Admitted cases, you don't have a recognized qualification either by the state of Orissa or by AICT, but you continue. You want regularization under the aid of the rule. The rule 4 says that unless your qualification is either recognized by the state government or AICT, you can't be regularized. That is their case.
That is, my lord.
You are relying upon some relaxation given by the government at the induction stage.
My lord.
But how will you take the help of the rule now?
My lord, the rule.
Under the rule, you are barred.
My lord.
That's the difficulty.
Only, my lord, will subject to your lordship permission. The rule, your lordship, the rule says, your lordship may see what are that. The induction,
if you can
up to the induction is rule 7. Thereafter, my lord, the direct recruitment. And the rule 9 is so far as the appendix is for the fresh recruitment. Direct recruitment is concerned.
No, for regularization.
I am coming. My lord, on that day, your lordship kindly visualize. On the 8/3/2019, why I am saying, my lord, on 8/3/2019, 5 rules were set up by the government. Paramedical, one is laboratory technician, another is multi-purpose health worker, another induction, same issue, same.
When you were inducted, which year? Before the rule came in force or after?
8/3, when the rule, the 19 for laboratory technician inducted, notified, on that rule, on that day, 5 rules was enacted. In all these 4 rules, for the purpose of induction, the qualification at the time of entry into service were taken into account. But in this laboratory technician case, they have stated that now the present qualification as per the direct recruitment has been taken so far as the induction is concerned. And your lordship may say, during the pendency, the government has recruited 1,000 laboratory technicians in 2021. And the rule says that those who are passed from the DMLT from government or recognized, they have to register before the council prior to the appointment.
See,
they have not relaxation.
We make it clear that we are hearing this writ appeal based on the records which were there before the learned single judge. That's all. And the rule. We cannot go beyond that.
Subject to your lordship's permission.
We shall not see any document which is not there on record.
No, only during the pendency of this, the government has relaxed it 2 times, same by invoking Rule 20. So far as the persons at the time of engagement.
Mr. Counsel, please stop this practice of picking out any paper from your pocket to present before the court.
Sorry, my lord.
This is impermissible.
Sorry, my lord. I will file through an affidavit. Your lordship.
You do whatever you want, but this is not the way. We'll show if the state government has relaxed, the state government may relax. We will not do that. We will not relax. According to you, that should be relaxed in the light of something which has been done in the background of the orders passed by the tribunal. They may take into account that also.
It is their prerogative.
It is their right.
Mandamus could be issued.
And Supreme Court can do that. Supreme Court has that power. It can do.
Bound by the rule, what to do?
Only, my lord, your lordship, kindly, they have sent for in the COVID period, your lordship, they have the role of laboratory technician, your lordship, they have sent for training and they have everything, my lord, they are utilizing since last 20 years.
Please understand that we are bound by law.
My lord, I pray before your lordship because
we cannot travel beyond law.
How many of you are there total?
Total, my lord,
around 900.
Around 100?
Around, my lord, 150.
150.
We will see.
Because, my lord, during the pendency, 1,000 posts of laboratory technician they have filled from the open market instead of regularly. Now again, the 700 they have advertised for the filling the post from the market, my lord. But they have not been regularized. In alter, my lord, in the time to time, at the time of recruitment of 1,000, even the persons, the candidates have not registered in the council, the rule was relaxed. And 2 times the government has relaxed. That is how we pray, my lord, since we are age bar and everything, my lord, we are serving since last 20 years. Your lordship, kindly.
Some of the similar situated persons who possess the same qualification as of the respondent, my lord, they have been regularized even if they have not approached the court, my lord.
We will see what can be.
And Doctor, before concluding, my lord, your lordship may see the documents which was given my brother. In 2013, your lordship, page 11 of the bunch of papers, the Health and Family Welfare Department on 13/5/2013 has issued a resolution for regulation that those have completed laboratory technician, those have completed 6 years on contractual basis, irrespective of AICT or anything not has been mentioned, my lord. And by invoking, when our services have not been regularized, we have approached before the tribunal. That is in 2016, my lord. The tribunal has taken that while disposing a batch of cases, more than 50 cases, that you take a policy decision since they have been continued, and 2013 rule says that it is approved by the finance department and it has not stated that AICT or recognized, that has not been mentioned. That rule has resolution has been mentioned. So thereafter, my lord, the 19th rule came into force. So on that day, my lord, the 5 rules were given. In those 4 rules, the persons at all the 5 rules are for induction of paramedical employees. Staff nurse, multipurpose health worker, laboratory technician, and multipurpose health worker female, that is, and radiographer. On the very same day, my lord, 6 rules were framed. In those rules, my lord, the persons sought to be inducted as per the deeming provision at the time of engagement of their qualifications were taken into account. So far as the laboratory technician is concerned, my lord, they have stated that the direct recruitment rule, that criteria, as your lordship just gone through the appendix, that has been taken as a result of which we could not be inducted. But all the other cases, my lord, the other paramedical employees, they have already been regularized by of the same rule, set of rules, my lord. And
was there any rule at any point of time that the persons having qualifications from institutions not recognized by the state government or AICTE could be appointed at any point of time? Was there any provision? Was there any provision that a person having qualification from an institution not recognized by the government or AICTE was valid qualification for appointment?
My lord, that was the relaxation given due to the shortage of given by the government.
That was not the rule. That was relaxation.
Rule was not there till
so
2019.
Therefore, this was never a qualification. You are saying that they have introduced new qualification.
So far,
we are putting the question. We are putting the same question differently. That was never the qualification. So you cannot say that on the date of your contractual appointment, you were qualified. And now in 2019, they have introduced new qualification. Therefore, 2019 qualifications should not apply to you. No. And therefore, a decision was taken in 2019 that yes, in whatever circumstance the persons were appointed, in order to meet the situation, extreme urgent situation, those were to be regularized, subject to the fulfillment of the conditions.
Only question your lordship raised, my lord, the rule 20 of the relaxation, your lordship
that is the only
taking into
that
the,
we will see what can be done.
We are,
see, Mr. Counsel, we as the
lordship visualize the problems of the respondents.
We visualize, see what is the height of this bench from that? 6, what is that? 6 feet or 3 feet? What is, I don't 3 feet. 3 feet, say 3 feet. So our vision is more. So what you visualize about your client, it is not that we are against them or we are against any litigant. It is we have our compulsions, we have our own limitations. So we work under those limitations. So we visualize more than what you visualize. But we are bound by law. And we visualize so many things, you know.
Government being a model employee, my lord, in one
model employer,
they have given a regularization in by implementing the order in some cases. Now in our
the government being a model employer should have made all the attempts to get qualified persons instead of those who did not have the qualification.
If this can send also, you are agree to go for training.
We will see. We'll see what can be done.
This certificate at page 17 is even recognized by Andhra government. This is issued by some Guntur college and all. Whether Andhra is recognizing. This seat is recognized by IMRGL TA Karnataka, sponsored by DRDA, STEP. What is this? SC Society, Government of Andhra Pradesh and India, affiliated to St. John Ambulance Society. What is this? What kind of institution is this? Hyderabad, approved by the Medical and Health Department.
That's also for your case is concerned.
Your Lordship,
Judgment is reserved. Now heard, the WA number. Also heard. Judgment.
Lordship is reserving not the judgment. Your Lordship, you are hearing concluded.
If you want to file a written submission, then very
You can do that.
And
If you want,
whatever document you want to give it.
that will help us. Please,
That I may be permitted within 7 days.
in 7 days, yes. Yes.
And they prepare, it is regarding only one
And
petitioner.
some, 1, 2, 4, 6, 3, 7.
No, how many petitioners you have? How many, you are representing how many petitioners? One,
How many
Three.
response are there?
Three.
Three, my lord.
Uh,
Three respondents.
In this case, and other cases also there, where
You are appearing in 687.
687 2022, 919 of 2022, and 1050 of 22, 1247 of 22, 1248 of 22.
Yes.
Then 1399 of 22, 1732 of 22, and 1754 of 22, 1755 of 22, 148 of 23, 552 of 23.
How many cases are there?
Around 30 cases, sir.
30.
Well,
5, 5,
And 1306.
So you just give a chart.
Well,
All right.
Well.
Give a chart and then limitation also.
my lord, in most of the cases, this first case, the 4 months, 5 months, my lord. In most of the cases, more than 1 year, 2 year limitation.
Give that.
And qualification of all individuals are from different institutions.
My lord.
None of them are recognized. Or anybody's qualification is recognized by the state government.
Recognized, my lord. No, they have to pass, but non-recognized.
All right.
All non.
All right. So just in the chart, or you also,
Well,
give the chart, the delay part.
yes, ma'am.
And
Well,
all right.
well.
So you give this thing.
All
You
these
are-
cases, the limitation and
The limitation
and the numbers I will give.
and numbers.
Memo of citation along with the memo, written note of submission. 10 days. Your Lordship, 10 days time. 10 days time.
10 days. All right. The rest of the cases go. The rest of the cases we are listing it them on say
These cases are covered by this judgment.
no.
One point of limitation. They are saying that
The point of limitation.
Only point of limitation.
The point of limitation we will have to consider.
Yes, well, I'll give all the details in all the cases.
List these matters on 2 weeks. Your this is the only which is not time barred.
Yes, ma'am.
This is the only appeal which is not time barred.
Some cases are there. I'll examine and submit that to that effect.
List other matters on
In my written note of submission, I'll
2 weeks. All right. Other matters will come after 2 weeks.
Well,
all right, you give your limit.
Excluding first item, other matters will be come on other day.
Yes.
including my matters.
Yes. No, this excluding first, all other matters, including your matter, will come because question of limitation, well, we'll deal with that. You are appearing in?
I am appearing for 10 cases in other respondents.
They are barred by limitation.
In all these cases, they are the petition is readable is barred by limitation.
All right. We may not condone, we may condone.
Well, in that case, I'll return note within 7 days.
Within what?
In past,
600 days delay, 600 days delay. And my senior is submitting that the COVID period is 35 2022. But my humble submission is that the Supreme Court decision that it is up to 28 to 2022.
We will see.
Item number 36.
Item 36, may I pray tomorrow?
36, what is this?
That is the regulation matter tomorrow.
All right.
Because of all this batch case, I am not ready in that case tomorrow.
As question. Yes. 36.
36, may I pray tomorrow?
All right.
Item 37.
As requested on behalf of the state.
Well, item 37, I was required to place an affidavit before my lords, following the rule, naming the rule, and actually, my lord, the affidavit was ready. But, my lord, I must submit before this honorable court that the affidavit was not in terms of my lord's order. So I have requested for a change and we have come for a discussion.
The state council has submitted that he needs 1 more week time to comply with this court's order dated.
My lord, 18/3/24.
18/3/2024. Stop as requested, list this matter on. Yes, Mr. Mishra, you are appearing in this case.
I am there. I am not well, but still then the interim order is there, my lord.
All right. In the interim order shall continue in the meanwhile.
Yes, my lord. Grateful.
My lord, when the date is fixed?
1 week, Mr.
No, 38.
May it please the Lordship. Lord, the question which falls from my Lord's consideration is this one, as to whether a retired work charge employee.
In 38, sub item 2, I seek permission to file an affidavit.
The Lordship may take Balabhadra Naik, others can follow me.
I am for the respondent number of Balabhadra Naik. I want to 1 week time to file an affidavit.
Not wrong. Let him complete his submission.
Only next week, my lord.
Why?
I have filed an affidavit, preparing affidavit.
Let us understand in the meanwhile the issue involved.
Yes, my lord. It's a very short issue, my lord. The question is, my lord, whether a work charge employee who has retired as a work charge employee is entitled to pension under the Odisha Civil Service Pension Rules 1992. Shortly put, my lords, Rule 18 of the rules is a direct bar to this. That's the point. Now, what happens is, my lord, this Balabhadra Naik, he was a work charge employee. He retires. And after his retirement, he pleads that I have come to know some cases are going on. And therefore I have waited. And now I'm told that Supreme Court, Honorable Supreme Court and Honorable High Court have in some cases said that I am entitled to pension. And therefore what he does is, he goes to the Odisha Administrative Tribunal after about 7.5 years. And his only prayer is that I'm entitled to pension and pensionary benefits. What the learned single judge does is, he renders two findings. A, he says, he is entitled to regularization, which was not his prayer at all. And B, because he is entitled to regularization, and there is one case of one Narsu Pradhan. Narsu Pradhan, the tribunal had said that similar situated person will get pension, and Narsu Pradhan has been upheld by this Honorable Court and the Honorable Supreme Court. By Supreme Court only says SLP dismissed. Your Lordship knows the law. And therefore he is entitled to it. The learned single judge does not advert to any provision on the rules on the basis of which he is entitled. Your Lordships are rising for lunch. I will address your Lordships after.
Then later, next week, can we adjourn?
Fair enough. Fair.
Meanwhile, in this item number 13, I'm serving a copy also, counter also in that.
39.
Then say 2 weeks.
38.
2 weeks.
Yes.
All right. As requested on behalf of respondent number 2.
Sole respondent in sub item. Sole respondent in sub item.
Respondent in sub item 2.
But may I have a small request? The state of Orissa versus Balabhadra Naik, which I addressed your Lordship, may be taken up as the lead matter in that list. And all interim orders to continue. Grateful.
Interim orders I'll continue.
Let item 18 come thereafter.
18, yes, in 18 will be there.
Very well.
All of the matters in the same item, ma'am. The 38, 18, as my learned AG said, in the same state versus whatever the night will come. And for that also, I'm filing a count.
Let your matter also be heard together.
Very well. Deeply
obliged. Time of making submissions, you can say that your matter is distinguishable on facts and
very
also.
Very
We are not in a
very
tomorrow. We'll see tomorrow.
Tomorrow. The matter will come tomorrow, man.
Yes, tomorrow.
Number 39.
Item 39, if you please, Your Lordship. In this case, it is relating to an advertisement, my lord. Basically, there is two kind of aspects, my lord. One is technicality, another is merit. So, in the impugned judgment by the learned single judge, my lord, the impugned judgment by the learned single judge, my lord, para number 29, 30, and 31 is relating to the place where a person who has already applied for that advertisement cannot challenge the same advertisement before this honorable court. Once he has been a participant in the advertisement, he cannot challenge the same. So in this case, my limited contention, without going to the technicalities of the case, my lord, is that this particular appellants, they were never a party to the advertisement, my lord. The advertisement was published, the challenge before even applying into it. But in that order, the impugned judgment, my lord, by the single judge, my lord, in that the para number 29, 30, and 31 specifically states that we are a participant in that advertisement, but we are not a participant in that advertisement. On the last occasion, my lord, in 18/4/2023, by this honorable court, my lord.
Which paragraph you are talking about?
No, my lord. This is judgment, last order of this court.
Judgment. Which? Yes.
Last order of this court, 18/4/23, ma'am.
What is your submission?
My lord, so
there was an advertisement.
There was an advertisement, my lord.
For what?
For the post of teacher, assistant professor, and government training colleges, my lord.
So you applied?
No, I never applied. I challenged that advertisement, my lord. That is my limited contention. Because then the single judge,
all right, you challenged the advertisement.
My lord.
Then what happened?
I challenged the advertisement. The matter was pending before the learned single judge. And then eventually I got an interim order to sit in that advertisement. But they also couldn't allow me to sit in the advertisement because I never qualified those qualifications as prescribed by the advertisement, my lord. But meanwhile, I was never heard whether this, in the batch of cases which was dismissed by the learned single judge, in the batch of cases I was included, that I was also a participant. That's why my case was dismissed. So my humble submission before Lordship, that this matter may be reverted back to the single judge and may be heard in merit. That's my limited submission, my lord.
He says that he had challenged the advertisement here.
Where is that finding of the?
All right. So it happened because a batch of writ petitions were heard, and in which your case was also included. Then you could have filed a review.
Single benchmark. That's why
the error apparent on the face of record. So where is the question of LPA?
It is a factual error.
And apparent, you are saying it was not considered. The single judge says that you participated. The fact is that you did not participate. And it happened because batch of applications were heard. So instead of the appellate court remanding the matter back to the learned single judge, it's better if you file. There is something.
That part may be included, may be heard before in merit before the single judge. That's my limited
Withdraw, we are giving you liberty. That will be better.
Take the liberty, file a review.
For the
because this is intra-court appeal, Mr. Counsel, please.
My lord may also direct me to revert it back. That is also the same way. Again, filing the review also, it's also to that extent, my lord.
No, there is difference.
My lord.
Here we set aside the order. All right. And there the learned single judge recalls the order. So this is the difference.
Or my lord, my WPC may be just heard. That's my limited prayer.
What the learned single judge may decide after recalling the order.
We simply withdraw. Instead of asking us to pass on it, you withdraw.
Just see the kind of learned counsel appearing on behalf of the appellant has submitted that he had not participated in the process of selection. Rather, he had challenged the certain stipulations in the advertisement itself, laying down qualification. So he submits that while disposing of batch of the writ applications, the petitioner's writ petition also came to be disposed of on the principle that he could not have questioned the process of selection after having participated in it. Stop. Next. After some argument, he seeks permission to withdraw this appeal with a liberty to make a review application seeking review of the order to the extent the same relates to the appellant. So this writ appeal stands disposed of with the liberty, disposed of as withdrawn with the liberty as sought.
Item number 40.
Much obliged.
Please, Your Lordship. This is a PIL where I am challenging the inaction of the Odisha's Real Estate Regulatory Authority in not being able to execute a single order of its due to lack of manpower and infrastructure, and for which till date not a single order has been executed from the date of inception of the authority in the year 2017, Your Lordship. Your Lordship, the authority passes two kinds of orders. First is a direction to a promoter to pay a certain money towards interest or compensation. That is executable through the Public Demand Recovery Act by sending it to the collector. We have no dispute there. And second part is issuing a direction to a promoter to do certain things or abstain from doing certain things. Now that part, the ORERA is to itself execute it, but instead of doing so, it is sending it to the civil courts. And it is merely only acting like a post office. All cases are being sent to the civil courts, and for which the litigants are facing harassment. Not a single case has been registered before the civil court. And civil courts are also now returning back those orders to the ORERA. I'll just show your lordship the relevant statutory provisions which mandates the ORERA to itself execute its own order. Your lordship, it is at page 28.
I had this matter in extensive. Lordship may kindly recall
at
your
page
lordship have had
28,
this
your
matter,
lordship.
and your lordship has gone through the statutes, and the statute clearly says, as far as possible, my lord, the language is, in the event of its inability to execute the order, ORERA shall send it to the civil court. So your lordship, that day, my lord, last occasion when the matter was there, your lordship had taken a view that we'll give a direction to the state government to provide necessary infrastructure for the purpose of executing its order. Wherever they will not be able to execute, they will be able to send it to the civil court. Because the language, my lord,
is an exception, not the rule.
Yeah, it must be the exception.
Exactly.
That is what your lordship had taken a view. And
where is that?
My lord, rule 26 sub rule 2. This has come by way of an amendment, your lordship. It's at page 28 of my brief.
These rules called Odisha Real Estate Regulation Development Amendment Rules 2019.
I have annexed it at page 28.
28.
Page 28, annexure 3.
Yes, it's there.
Yes. I'll read it, your lordships.
No, this is amendment.
Yes, this rule was inserted by way of an amendment because earlier there was no provision for an execution. Rule second serial number, rule 26 sub rule 2.
Yeah.
So, your lordship, the only case is that in the event of inability to execute the order, the ORERA may send it to the civil court. So that inability cannot arise because there is no infrastructure or manpower. The state cannot itself create that inability. Otherwise, the purpose of statute gets frustrated. The preliminary, at the first instance, the ORERA is to itself execute its order. Because under section 79 of the ORERA Act, even the jurisdiction of civil courts are barred. So the legislature intended that these matters should be dealt with by a specialized authority, which is the ORERA.
No, that is for the purpose of adjudication.
Adjudication, indeed, Your But ultimately, if I have to go to the civil court at the last to execute my orders, it becomes the same thing, Your Lordship. And that is contrary.
More effective. All over the country, my lord, I have given a chart.
My lord, even
chart I have given all over the country. I have given all the state rules. They are in the line of the rules which have been formulated by the state government. So what my lord and my lord petitioner wants that, he wants to rewrite that particular order or to amend the order to be, the legislation to be amended by this court.
We are concerned with the rules prevalent in the state of Odisha, which clearly says that the order passed by an authority will be executed in the same as if it is a decree or order made by the civil court in a suit, and it shall be lawful for the authority in the event of its inability to execute the order. Now that there should be some constraint for the authority to not execute its order. But merely lack of manpower and infrastructure, my lord, in my humble submission, that cannot be the reason. Then
where is the data you have regarding how many cases are sent, how many cases are decided?
Yes, your lordship.
Data do you have?
I have given it, in fact, at page 47, your lordship, I had filed an RTI act. The ORERA has written that no case has been executed by the ORERA, no case has been executed by the adjudicating officer of the ORERA, no document has been sent to the police to execute the orders of the ORERA. So it's a complete nil. They are acting like a post office. I file a case, they send it to the civil court. That's it. Without application of any mind. My problem.
How a decree is executed?
My lord, here the ORERA will itself execute it.
So whether the civil court has a police force?
No, that the ORERA has written it. Just
no, what infrastructure?
Exactly. That the state is to explain. The state in its town.
Lawsuit from the council filed by the state government, said page 3 paragraph 6 have given the details, how many cases have been disposed of, the execution by the ORERA, how it has been referred to civil court. Details have given, not nil. So last week I come to that counter filed by the state.
The RTI information at page 47.
47.
Where are the questions? What question you have put? The answer comes depending upon the manner in which you design the question.
Yes,
what are the question you asked?
And we don't decide on the basis of the information which you receive under
that data also I have given.
I filed a document. He had repented to the ORERA authorities not, and he repented that the 30th of August 28 has been disposed of, and immediately thereafter this interpretation has been filed. So Lord, I will come to my
And who are you?
My lord, the petitioner had filed a case before the ORERA in the year 2018. He got an order in the year 2018. Till today, he is not being able to execute his orders.
So this is public interest?
Yes, your lordship, because everyone is getting harassed. And even your lordship.
Not done.
Completely, you are private litigation. You can't.
Now I have annexed. I have annexed a document where now the civil court is sending back the orders to the ORERA itself.
Maybe you are not agreeing with your private litigation.
And in fact, I have also annexed, my lord, the counter of the state. They say that creating parallel infrastructure in the ORERA for execution of orders will be an unnecessary burden on the state.
A order which was passed in your favor by ORERA,
yes,
you want to get it executed through ORERA only.
Through ORERA, which is the statute says.
What is the prejudice caused to you? Your order is being executed through civil court. What is the prejudice caused?
It is not being executed because I don't know when the ORERA is sending it to the civil courts. The civil courts are sending the orders back to the ORERA. We cannot execute it.
In your case, tell us when it was sent back.
No, the petitioner doesn't have any information when it is being sent to the civil court. All the litigants, no one is being informed when their orders are sent to the civil
court. You talk about yourself because
yes, in my case also, we do not know when there is no intimation from the ORERA that your order is being sent to the civil court, you go there. There is no such orders.
There must be some proceeding.
No, because my allegation has been accepted by the state. State says that creating a parallel infrastructure in the ORERA for execution of orders will be an unnecessary burden.
Counsel, we cannot treat your matter to be a public interest litigation because of your private interest.
My lord,
and you have the courage to tell the court that I don't know where your matter is pending. When was your matter sent to the civil court? When the civil court returned the matter to RERA. So you don't have any idea, but you have sought every information under the Right to Information Act. These are the things. These orders have been passed, not executed. This is unfair.
You could have got the information through RTI in so far as your case is concerned. That you didn't do. You make it a general this thing.
In my case, I have annexed the final order passed by the ORERA that they have sent it to the civil court. But
so you want to intimidate RERA and all the agencies?
I want the infrastructure to be there.
No. What infrastructure? Whether the civil court has, whether the executive municipal has any police force?
No, your lordship.
Then? What infrastructure? For enforcement of, they need police force.
No, that is not never my claim, Your Lordship.
Then what infrastructure? Tell us.
No,
we need infrastructure for implementation of our orders.
No, that is the stand of the ORERA, that we do not have infrastructure. That is their stand.
All right. Their stand, then.
Your Lordship may kindly come to page 43. That is their stand of my
Seen the counter affidavit filed by state.
Yes, Your
At
Lordship.
page 60. They have given detailed data. It is not that every case they are sending.
Your Lordship,
The data is given here.
At page, Your Lordship.
Page 60 of the counter affidavit filed by the state.
They have sent 31 cases because in those 31 cases, only the requirement of there was a direction passed. In fact, if the state can show one case where the ORERA is itself executing its orders, I will completely bow down. I will have no case, Your Lord.
You talk about your case.
Yes, my Lord. For that,
who has authorized you to file a PIL?
No, Your Lordship. No.
Where is the certification?
I have given a representation under the PIL rules.
Certification in the petition that the people have authorized.
No, no one has authorized.
Then representative capacity, how are you filing?
I have only given a representation on the High Court PIL rules, and thereafter I have filed. Because that was not disposed of by the ORERA and the state, Your Lordship. So it is not my case that they are not having an infrastructure. It is their case.
That is disposed of.
I have annexed that disposal order. Actually, if I want to my counter affidavit.
That was never supplied to me. That came first in the counter affidavit. That was never supplied to me, that order. They have first time annexed it in the counter affidavit. So it is not my case that they are not having infrastructure or manpower. It is their case that we are not having manpower, so we will not execute it. So I'm only concerned that let the appropriate manpower and infrastructure may be provided so that the orders may be executed easily rather than keeping it pending for years together, Your Lordship. Only my limited prayer is that if an authority itself says...
What is your stand?
Also, may kindly see, my Lord.
No, what problem? What infrastructure do you require?
We don't require any infrastructure. What we have said is, what my law enforcement wants is the other part. What your Lordship read 26(2). It's inability to execute. He wants with this civil court. We do not have all those infrastructure that we have written. We have not the order because we are not being able to execute the order because 26(2) is there. 26(2) says we will try our level best to execute the order. Wherever there is an inability to execute, we'll send it to the civil court.
All right. Sure.
Only last one paragraph can I show?
What?
Your Lordship, page 43 of the writ petition, where in an execution case, what the ORERA has given its stand. I'll read it only. I'll just read it. The other part relating to direction shall be executed by the authority or by a competent civil court. In case of delivery of possession, civil court is well equipped under the provision of section order 21 CPC to enforce an order through the process of the court. The authority does not possess the power of a magistrate to direct a party to serve civil prison in case of violation. Even it may not be possible on the part of the authority to take extraneous help of the police for enforcing its order. The authority has no manpower to execute its order at the spot, taking the help of the police. So this execution case is being sent to the civil court. This is their...
That is the reason given.
That's the right reason.
So this is happening in every case.
We intend to impose cost also, not token amount, not more. Like 2,000. The petitioner had booked a flat being constructed by one Messrs. Vipul Limited, Bhubaneswar. Stop raising some grievance against the builder. The petitioner had approached the Odisha real estate development, what is it?
Regulatory authority.
Odisha
Real estate regulatory authority.
Real Estate Regulatory Authority under the Real Estate Regulation and Development Act established under the 2016. Oh, stop. By an order dated 12/6/2018, the ORERA had directed in the petitioner's case to complete the apartment and hand over possession within 2 months and to pay interest for delayed delivery. Next. According to the petitioner, the said order of ORERA has not been executed so far. This is your case?
Yes, Your Honor.
Executed so far. Full stop. The petitioner has learned counsel for the petitioner has submitted that he has no knowledge as to whether the ORERA has referred the matter to the civil court for execution.
It has referred. That much knowledge I have. That order I have annexed.
You are next.
Yes.
You said you learned recently.
I have no knowledge. That's what you
No,
say.
they have sent it, but when they have sent it, when I have to go there, that has not been communicated to me.
Oh, that they have no knowledge that in consonance with the requirement under rule, which rule is that?
26 sub rule 2.
Page.
Which page was that?
20.
Page 28.
28. Please.
Under rule, sub rule 2 of rule 26 of the Odisha Real Estate Bracketed Regulation and Development Amendment Rules 2019. The matter was referred to the civil court for execution. Of the said order. Stop. Learned counsel for the petitioner has submitted that he has no idea as to at what stage the matter is pending before the civil court, in as much as no date has been communicated. No date has been communicated.
No, Your
So stop. Next. The petitioner has ventured to file this writ application in the nature of public interest litigation, raising a grievance that there is no mechanism for execution of the orders passed by the ORERA. So he submits that Orira has expressed inability in execution of its own orders, and all the orders are being transmitted to the civil court for execution in the light of the provision under sub-rule 2 of Rule 26 of the rules. Stop. Learned counsel representing the state has denied this submission and has referred to the averments made in the counter affidavit.
Yes, sir.
Where is that?
Paragraph 6, no.
Paragraph 6, page.
Page internal page 3 of the counter affidavit.
Counter affidavit filed by respondent number. Was it party number?
Page 68.
68.
Start from 68. Affidavit of Devasi Singh.
With a special reference to paragraph 6 thereof, which reads as under. So next. Sub-rule 6, sub-rule 2 of Rule 26 reads as under. So it is apparent from the language of sub-rule 2 of Rule 6, Rule 26, that the RERA has jurisdiction to execute its own orders and may refer the matter to the civil court for execution of such orders where it finds it difficult to execute the order. Stop. Next. It is apparent from what has been disclosed here and above that this writ petition filed by the public interest, filed by the petitioner in the nature of public interest litigation is thoroughly misconceived, is an abuse of the process of the court. It is manifestly in the nature of private interest litigation. The petitioner has his own interest. Stop. Surprisingly, the petitioner has not made any effort as regards, own case according to learned counsel for the petitioner, but he has collected informations regarding non-execution of the orders passed by RERA under the Right to Information Act. Stop. The conduct of the petitioner in the court's opinion deserves to be deprecated and is accordingly deprecated. Stop. Next, this writ application is thus dismissed with a cost of rupees 2,000 to be paid by the petitioner in the account of Odisha State Legal Services, High Court of Orissa Legal Service Committee within 1 month from today. Yes.
Item 41.
Thank you, Lordship. This batch of writ applications, here members, we have challenged the levy of additional fee by the next of 5 minors. This additional fee minors, they have already, the Union of India has already filed the reply minors counter. In one case, that is WPC 34108 of 2022. And that has been, my lords, Adopted in all cases, my lords. WPC 34108 of 2022.
So you are challenging this notification for
Annex of 5, my lords,
2021.
page 56, my lords.
Yes.
That is they have levied the additional fee. So far the statute, the Odisha Motor Vehicle Tax Act 1988, my lord, section 211 provides only the levy of a fee. Nowhere it is under the statute there is to levy the additional fee, my lord. Additional fee is the nature of the penalty, my lords. So all these matters earlier in 2016, they have issued another notification that were in challenge before the Madras High Court, and that a judgment has been struck down by the Honorable Madras High Court, and that has been SLP filed by the Union of India. That SLP is pending, no stay has been granted. Then, my lords, in our Orissa High Court, that 16 notification has been challenged. Two judgments of this Honorable Pass I have annexed, that is Annexure 3 and 4, my lords. There also that notification regarding the levy of additional fee has been struck down. My lords, so far this new notification of 2021, those are other high courts also challenged. In Kerala High Court that has been challenged. I have given the copy of that. The interim order has been passed not to collect the additional fee. Also the Karnataka High Court in interim order stayed the impugned order.
What is the controversy?
Yes. So controversy is, my lords, they issued this notification levying the fee and additional fee.
Under which power?
There is no power. That is, the power is only under section 211 to levy the fee, my lords. I am pressing to your lordship. They are counter your lordship. They supported our case, my lords. Your lordship may see that counter filed by the Union of India.
Let us see. Let us understand the controversy. Then only.
Yes, but
what is the legal issue involved?
Legal issue, my lords. Your lordship may go through the section 211 of the MB Act, my lords. Section 211 of the MB Act. They are, my lords.
May I short interview, my lord? Last occasion, they have cited the Karnataka judgment. I requested my friend to serve the copy, then I will take instruction whether stay order has been passed or not. They didn't serve the copy till date. Apart from this, three things I want to enlighten, my lord. There is three notification. What is 2016, 2017? Ministry of Road Transport has notified this. Then 2021. As regard to scrapping policy is concerned, or whatever levy or input, whatever they have submitting with my lord, that was subject to the Supreme Court. So what I am praying, my lord, before hearing the matter, our High Court also passed two other orders, quashing the notification of the Government of India, and because against the order of the Honorable Chennai High Court, the government would have preferred to file SLV with the SL before the Supreme Court, and it is pending. Admittedly, I got the instruction that there no stay order will pass against the order. I filed the SLP in this regard. So what I am praying, my lord, lordship may keeping to some other day for hearing after 2 p.m. Then we have to file pleadings in all respect. Then hearing will be concluded. Otherwise, because my lord, they are saying that Karnataka has passed the order. Our own High Court passed two orders. Matter is pending in the Supreme Court. We don't know what is the prayer. Whether the 2016-17 notification was challenged, or it is included 2021 notification. That instruction I don't have. That's why I am praying before.
But
the scrapping policy has to be
notification is under challenge before any other High Court.
Yes, yes. In Karnataka High Court and Kerala High Court, their interim order has been passed, my lords. I have given that orders, my lords.
Same notification.
This 21 notification, my lord. And that is Karnataka.
Last occasion also, my lord Chief Justice directed you follow what is the status in the Supreme Court.
That is pending.
We will got the order sheet of this Honorable Supreme Court. We found that after it was a notice, the other side is not appearing with the court. That's why it is adjourning again and again. The counsel is not appearing. He said that I have no instruction. That's why it is deferring day by day. After getting the order in their favor, they are fled away. They are not coming and attending the court. They are not cooperating the court for education.
In their counter, you will also see paragraph 5. Very clearly, they say that they have power only to levy the fee, my lords. I am placing that paragraph 5 of their reply, my lords.
See, such issues are not decided on the basis of pleadings. rather on the basis of statutory provisions.
Yes, there is no statutory provision for
Therefore,
additional
once
fee.
we are satisfied. that
Yes, I am
there is
placing
no
before your
such
lordship section 211.
That is the best way to understand.
Yes, ma'am, I am placing yours, section 211, your lordship, ma'am. Section 211. That is chapter 14 and miscellaneous, section 211, power to levy fee. Any rule which the central government or the state government is empowered to make under this act may, notwithstanding the abuse of any express provision, absence of any express provision to that effect, provide for the levy of such fees in respect of application, amendment of documents, issue of certificates, licenses, permits, tests, endorsements, badges, plates, counter signatures, authorizations, supply of statistics, or copies of documents or orders, and for any other purpose or matter involving the rendering of any service by the officers or authorities under this act, or any rule made thereunder as may be considered necessary, provided that the government may, if it considers necessary, so do so in the public interest by general or special order, exempt any class of persons from payment of any such fee, either in part or in whole. So far
So this is the power.
Section 20. And you lordship may see the section 64. What is the rule making power, my lord? Section 64 of the Motor Vehicle Act. 64. Subsection 1(o).
No, this is the power for levy of fee.
My lord, fee only. Fee.
So according to you, this fee means fee.
My lords.
Not additional.
Not additional fee.
So had there been no such levy of fees.
Fee, my lords.
Levy of fees. What is the significance of this such?
Any service, my lords. Such.
No. For levy of such fee.
Such fee, my lords.
Yes.
Fee, that is already in the Madras High Court is very explained clearly, my lords. Madras High Court judgment, I have already given the copy, and that judgment, how this fee, earlier, my lords, before 1992, that
so
was
this additional fee is in respect to what?
that has been, one committee has been constituted. They advise to levy, to enhance the fee and impose the additional fee, but subject to the amendment of the law. That judgment is there, my lords.
So such fee in here
fees
may mean such amount of fees.
My lords.
Such amount of fees in respect of applications, amendment, one
Yes,
application,
yes,
second
yes,
amendment, third certificate, licenses, permits,
yes, ma'am.
etc.
Yes.
This is what you submit.
Yes, my lords. Then your lords.
And what is this the additional fee?
Additional fee, that is fine. My lords, so far the
Additional fee?
That is additional fee they impose. Suppose so far, my lords, that is one is fitness certificate. Suppose, my lords, there is a fitness certificate. If your lordship see them, my lords, they charge the fee and they charge ₹50 per day towards the delay in applying the fitness certificate, my lords. That is your lordship may see the annexure 5, my lords. Annexure 5, page 56, my lords. That is page 57, your lordship may see. That is so far the serial number 4, page 56, your lordship, annexure 5, there is a new notification. Serial number 4. They levied the issue of certificate registration and that is renewal of a certificate registration. They charge the fees. Then, my lords, page 57, your lordship may see the note 2, page 57, page note 2. In case of any delay in applying for renewal of a certificate of registration, an additional fee of 300 rupees for a delay of every month.
Where is that? Where are you reading?
That is page 57, my lords.
57, which part?
Note 2, my lords. In the middle.
All right.
In case of a delay in applying for renewal of a certificate of registration, an additional fee of 300 rupees for delay of every month or part thereof in respect of motorcycles and 500 rupees for delay of every month or part thereof in respect of other classes of non.
You are challenging this?
this point only, 300, 200 rupees, I'm challenging.
This part you are telling me.
And note only additional fee. Next you will see, maybe see the page 58. That is page 58, my lords. That is another note is also there. Additional fee of 50 rupees for each day of delay after expiry of a certificate of fitness shall be levied. So there are two columns, my lords.
So according to you, for delay, there should not be any.
Yes, my lords. So that has been struck down, my
You
lords,
are
because
questioning the source of power.
source of power, my lord. Yes, my lord. Only because they don't have any power to levy the additional fee, and all the high courts have decided it. And
Where is the one decision?
I have already annexed to our own high court decision, my lords. I have annexed.
Where is
Annex 3. Copy of judgment dated 1/2/2019. That is page 22 to 24, 44, my lords. That's our own high court judgment, my lords. That is Dinabandhu Sahu versus Union of India and others. Your lordship.
Yes, 29, page 29. The argument is levy of
That is
additional
your
fee
lordship.
cannot be held to be justified by
That is relevant pages, my lords. Paragraph 11, page 43, my lords. Running page 43. That is internal page.
Fact stated above.
In view of the facts stated above, the improved notification of so and so. Column number 3 of the table, which has been issued by the central government, is traveling beyond the scope of the act. And the same is without authority of law. Therefore, the contents of the petition are required to be accepted, and the same is accepted in view of the fact that the notification already been quashed and satisfied with Madras High Court. In view of provision of law, the same is applicable.
So where is this notification? Have you annexed 29/12/2016?
That notification I have annexed, my lords.
Where is it?
That is annex 2, my lords. That is annex 2.
Yes.
Page 16. Page 16, my lords. Page 16.
And page 19 is the additional fees.
That is 20.
Page 19, note 2.
Yes. 20 also, 20 is, that is grant of renewal of certificate of fitness.
Page 19, note.
Yes, note, my lord.
This was question, which the High Court says that you don't have the power.
Subsequent lordship may see the paragraph 12 again. In paragraph 12, the High Court also explained, I am just reading that. Page 43, lordship may see. These parties are directed to abide the decision of the Honorable Supreme Court. Since the central government has already challenged the impugned judgment of Madras High Court, they are not required to challenge this order. However, if the petitioner want to intervene in the application pending before the Honorable Supreme Court, it is open to the petitioner to intervene and prepare appropriate application to plead the case before the Honorable Supreme Court.
But already discussed, paragraph.
But this observation is there.
Paragraph 11.
No, that is even then. That is regarding that 2016 notification.
Yes, madam.
16.
Now
They are 21.
Now again the same thing you have repeated in 21.
Then there is in the meanwhile a scrapping policy has been come into force. Because this scrapping policy, that period of time, there's no scrapping policy is there, man. The scheme of scrapping policy came into force after that. And public interest, and in 2000, that's why in 2021, this another notification came into force.
Paragraph
in that notification, it was specifically stated about the Rule 81. The rule, I'm just enlightening my lord. This Rule 81.
There is no power. Let this say.
Serial number 11 was
stated so.
Stated, my lord. This Rule 81, the Central Vehicle Motor Vehicle Rules 1989. Then Rule 81 says fees. The fee which shall be charged under the provision of this chapter shall be as specified in the table below.
Just a
that is, I'm just reading, my lords, paragraph 13 of that judgment.
But
Take
what do
it-
you say that because after the 2016, this judgment and all, the rule is amended, so therefore we are imposing. If the statute bars you, how can you on the basis of?
No, my lord, not like this. After the scrapping policy came into force, the 2021 notification came into force, say that there is a, that's why I'm citing the rule 81. The previous rule 81 was consequentially, it is taken care by the rule 62 subclause 2, my lord. What is that? I'm just clarifying that. This rule 81.
How many repetitions are there?
My lord?
Around
3 notification, 2016.
around 160 or 70 writ petitions are there, my lords.
Writ petitioner. How many writ petitions are there?
Yes.
60 or 70 writ petitions now.
No, how
listed.
many persons is my lord is?
No, writ petition.
Writ petition
It's
is
all
spending
listed.
more than 100, my lord. This is
Yes.
my lord. Yes,
Yes,
it is spending for my lord. That's why I'm praying, my lord. Let's make keep it some other day.
No, how many cases are listed?
Listed around
Listed
60,
about
70 cases.
60, 70 cases.
Can you give the list of all such cases? We can fix a particular case. and
Yes,
here you
exactly.
find
Yes.
In the meanwhile,
High Court view,
And also Kerala High Court.
there are two views. Contradictory view or same view?
Interim orders are passed.
Interim orders passed.
interim orders are not due.
My lord.
Not views. Finally, it is not.
No final.
No final.
No High Court has decided.
But our own High Court,
We are
Justice Muralidhar, they refused to say,
no, not.
and there is pending for adjudication. Some matters are there. We can also provide the list.
We can assure you that all the matters come, there would be no requirement of passing any interim order. We shall be deciding the matter.
Your lordship.
Very fine. I will admit.
So we are adjourning the matter for 2 weeks.
Deep.
We will take up the matter at 2 p.m.
Deep blue light.
We will hear the entire.
Your
Issue
lordship.
is common.
Yes, common also.
Issue
Your
is.
lordship, see the notification section 211.
We will
They have
see
said-
everything.
Issue is same, my lord.
We see everything. We will also try to understand from the statute book and from what you submit.
And your lordship, 2016 notification has already been passed by this honorable court.
We will see that.
Yeah.
That is 2016 notification.
Same notification, old wine in new bottle, man.
No.
Yes,
That's
your
not true. It is not like this.
Right into data.
My lord.
Even if there is a division bench,
Ma'am.
we don't know what, we don't form our opinion on the basis of, till we write the last sentence of an order.
My lord.
We are ready to change our opinion.
Yes.
All right.
Your lordship.
So what is there, whether we agree with the division bench decision,
My lord.
whether how, to what extent the division bench decision will bind us. So these are the issues which are involved. You any other court on 21.
21 no, man.
On 21, there is
No.
no adjudication. On
The
20
pending, man.
2016, there is adjudication.
Several
by
High Courts
the-
are there.
Several High Court.
Several High Court, which is pending in Supreme Court.
Pending in Supreme. No stay has been granted.
In the meanwhile, if you can,
Because those states, they are getting the benefits, my lords. In Kerala, they are getting.
Kerala getting, Karnataka getting, we are the persons, my lord, suffering, man. Odisha. Your lordship. Visualize this.
For last 1 year, they are getting benefits.
can you give us the list of cases?
Already there, other cases are new cases are there.
All right, so we can adjourn it for tomorrow. All right. Tomorrow you give us the entire,
Right.
all the cases.
Right.
So that we may direct all the cases to be listed along with this. And in the meanwhile, you may file counter affidavit.
Already filed, get the counter.
One case we have
One
filed.
case they have already
If
filed.
necessary, we can, other case we will try to file all this. If required, additional is required, then we'll
They have
file otherwise.
accounted in all cases, my lords. They have
It's a
written.
legal issue.
Only I want to place this policy, scrapping policy and other. notification
Scrapping
came into
policy is different, my lord. This is a 50 rupees fine. Why is there
That's why it's coming.
additional
They are-
fees?
They are not understanding what is there.
Why
After
scrapping policy is
2016,
different?
17, scrapping policy came into force, then Start all these things.
Without the law, you
Yes.
cannot do it.
I'll try to convince my lord.
All right.
You try and you also try. My lord, my learned friend is.
We are making it clear that
My-
we should try to convince separately, not
My-
jointly.
Exactly. Karnataka also can give.
Indian government is knows everything, my lord.
The issue is coming about protection of the environment because Higit
That should be
school
law.
nursing and.
Let us see, let
Without
us
the law, then you can.
That argument can be made outside.
Obliged.
And I am for petitioner, my lord.
Item 42.
Yes.
In respect of one period, we had claims of benefits, officers 3 to 5 times to file an detailed affidavit. Saying that honorably blocks, dump effect, so also different schemes of the state as well as center. How these blocks, small businesses are going to be covered and benefited to block the entire state block.
Last occasion, your lordship granted 2 weeks time.
So what do you want? Should we dispose it off without counter affidavit or we should?
No, my lord. Let them be directed to file counter affidavit. But my predicament is that still that the road condition is in a dilapidated condition. No construction work is going on.
One 170 meters of the road.
Completed. Out of 200, 2.50 meters. Out of 200 as per annexure 5, the total road length is 200, 2.50 meters.
200,
2.50 meters. Annexure 5. A writ petition, below. The report of technical team, page 41, annexure 5. Last paragraph. That as per the report, the length of the road is 202.50 meters, which is severely damaged for many knobs of potholes, patches, strikes, and not suitable for vehicular movement.
That was in 2022.
Yes. Out of it, they have completed 170 meters. So far, roadside ponds protection wall is concerned, they have not done it. Electrification, fixation of electric light, they have not done it.
So Kalai Gram Panchayat has been impleted.
Yes, Milord. I have filed one IA.
Someone
on
is
last occasion,
representing.
Milord?
Someone is representing Kalai
No, no,
Gram
no.
Panchayat.
I have already filed IA to implement.
Notice will not be given, only implement.
And also filed the consolidated cost title, Milord.
So we are allowing the IA.
Yes. That is IA number 3166 of 24.
Yes, this is a very important matter.
Yes, sir. Yeah, the also, sir, specific that will not be knowledge.
Why entire everywhere? Everywhere. So this has become important now.
So you are taking time for filing counter affidavit.
After the direction, retail application.
IA number 3166 of 2024. This application has been filed for implementing Kalai Gram Panchayat through its secretary as opposite party number
7, Milord.
7.
Yes.
Whose description has been given in the schedule of amendment. Full stop. A consolidated cause title has also been filed.
Yes.
Has also been filed. Full stop. Considering the nature of relief is the which has been sought in the present public interest litigation, this application is allowed. Let Kalai Gram Panchayat through its Sarpanch be treated as opposite party number 6 with the address given in this application. Stop. Issue notice. Party number 6. List this matter on 4 weeks. Stop. In the meanwhile, the estate shall be under obligation to comply with this court's order dated
20th February
2024. Please do it.
Item number 43.
May I please, Your Lords? Let's see. The opposite party number 4, Orissa Power Transmission Corporation Limited, made an advertisement and publishing the notification dated 10/8/2015, and thereby they sought some representation from the public with regard to laying down the transmission line, high tension tower lines.
Which order you have challenged?
I have challenged Annexure 10, my lord, the single judge, honorable single judge, that is Annexure 10, my lord. Order dated 20th July 2023. My lord, I just want to say the story first. What happened when the advertisement was made? So the peoples have made representation to the OPTCL and then to the revenue authorities. The revenue authorities, the district master and collector. So the assistance of the Tahsildar and other authorities. So they have held several meetings, and thereafter the collector has passed certain order allowing the compensation, that is Annexure 7 below. So in the Annexure 7, the collector awarded the compensation to two limbs. First limb is the high tension tower, which has been based on the area that the affected people will get 500 times, 5 times of the real market value or benchmark value prices, and where the land corridor of land underneath that line, that they will get 15%. So that order has not been challenged by the OPTCL. So thereafter, when another incumbent, the district master collector, they have reviewed that order. And in that review order, they have the said collector or district magistrate changed the entire things and said, whatever the compensation awarded in the past by the previous collector, so they say, no, you come under the Telegraph Act, and they are giving per acre either 1 lakh or 2 lakh, that is very minimum compensation. Whereas,
No, but why should you not have approached the district judge?
yeah, I am telling you, Lord. What happened? I am coming to directly the Telegraph Act under section 16(3). When the collector has passed an order granting the compensation 5 times of the benchmark value for the tower-based area and for the other area under the line under which the lands are covered, that is 15%, that has to be challenged by either party. I am coming to the directly section. It could have been challenged by the OPTCL if they are affected by the company, because I am not affected by the compensation, because the affected people are saying they are happy with what the collector has said. So instead of the government or OPTCL has, without challenging that order, because I am just reading if there is a dispute, who is to go to the district judge? So, my lord, section 16, subsection 3. If any dispute arises concerning the sufficiency of compensation.
Have you reproduced anywhere?
No, my lord, I have not reproduced that. And to be paid under section 10, clause D, it's an application for that purpose, either by the disputing parties to the district judge within whose jurisdiction the property is situated. If I am satisfied, if other side is dissatisfied, this is a higher compensation, they should have approached the district judge. Instead of doing that, my lord, what they have done, immediately they, after 9 months, they have filed a miscase in the guise of review. So what I am pointing out, my lord, there is nowhere in the Telegraph Act there is a specifically stated that the order for district magistrate can be reviewed. Unless it is stated in the statute itself, the district collector cannot review the order. For the sake of argument, suppose the review order has been passed by the collector, subsequent collector, but he has no power to decide the compensation. They may say whether they have allowed or not allowed to do to implement the scheme. But what they have said, I will come to that review order directly. The subsequent collector has framed 2 issues.
You are agreed by that review?
Yes, we have agreed by that review. Review is not maintainable. And thereafter also, the collector in the review power, he cannot go for deciding the compensation where the compensation has been to be decided by district collector. All these things have not been appreciated by the honorable single judge.
And a single judge in para 7 is relegated you to the district judge. You go and argue all this.
No, my lord. What I'm saying that I am challenging the review order, because first of all, when the compensation order has been passed by the first collector, the first order of the collector, if the OPTCL is dissatisfied, they have to move. And thereafter, we have contested that matter for the district judge. But instead of that, they have approached the same district judge thereafter in the review. What I am saying is the review is not maintainable, because unless it is stated in the special act. So one judgment I have also to refer, my lord.
No, you are not required to.
So that is the law, my lord. So thereafter, the learned single judge has also not appreciated the submission because thereafter government has come with
Where is the power of collector?
the power of collector, my lord, that is the compensation is section. I am coming, sir. Yes, my lord, section 16. If the exercise of the powers mentioned in section 10 in respect of the property referred in clause D, that the section is resisted or obstructed, the district magistrate in his discretion order the public authority shall be permitted to exercise them. So while doing so, the district magistrate has passed on. I am coming to another thing, my lord. When there was an advertisement, my lord.
Who determines the amount of compensation?
My lord, district magistrate.
Where is that?
That is in Electricity Act, my lord. That district magistrate is to, I am coming, my lord, 67, 68. And one thing, I am also coming to the rules, my lord. The rules also they have stated, the license rules also, that is district magistrate is to.
No, which act applies in your case?
My lord, that is I am coming. Now it is an all India phenomenon. Some states are applying the Electricity Act and some states are also applying the Telegraph Act. So because of there is a dispute arising in different states, so because there is a transmission between intra-states, it is not confined, though our case is within the state. So the government of India has come with a guideline in 2015 where the state government was participated therein. So being made to the affected parties, then in the real basis to calculate, suppose there is a house, then what will be the price? Suppose trees are there, that is to different price. So if your lordship, I will come to that notification.
We are trying to understand
Miller.
as to who is the authority either under the Telegraph Act or under the Electricity Act
Miller,
or under the scheme which has been framed.
Miller.
Who has to determine, who can determine the amount of compensation?
Yes, Miller.
Which line, whether it is a telegraph line or electric transmission line which is passing through your land?
Yes, Miller. I am not coming, that is district magistrate. I am just finding out and telling Miller.
These are high tension wires, electric wires.
Yeah, Miller.
So therefore, Electricity Act will apply.
Yeah, Miller. The electricity apply, but the notification, they have said section 164 will apply. So the 164 is referring to the Telegraph Act. That is their contention. But when district magistrate had passed
the question of contention, where is the notification? What was the process for acquisition of your land?
So requisition is that notification, Miller, that I am coming to the notification. Under notification, my land is covered.
All right, let us see where is the provision under the Act.
Act, Miller. This is still 1 minute. This rule doesn't license.
Come to section 68 of Electricity Act.
Miller, I am coming. Section 68, Miller.
Yes.
The overhead lines, Miller.
Yes.
So when it is disposing that, your lordship is referring to subsection 6.
Yes, 5.
5. Where any tree standing laying the overhead line, where any structure or other object has been placed or has fallen near or overhead line subsequent to placing the line, interrupts, interferes with or is likely to interrupt or conveyance or transmission electricity or the accessibility anywhere, executive magistrate or the authority specified by the appropriate government for the applications. Millard, I will come to rules where it has been said the rules made under that. Yes, rules are there. Shall in respect of the existence before placing it for a line and person interested in trees or compensation. But I am coming to the rules framed there.
What to the person interested in the tree, such compensation as think reasonable, and such person any recover of the same price.
Miller.
Your entire case is
Miller.
That there is some authority A who had to determine compensation.
Compensation, Miller.
That had determined your compensation.
Miller.
Thereafter, if someone was aggrieved,
Miller.
Could have gone to B.
Exactly, Miller.
All right.
Miller.
You were not aggrieved by the order
Miller.
passed by A.
Miller.
That was in your favor.
Yeah, Miller.
This is your submission?
Yeah, Miller.
They
A
find
did
review
not-
which was not maintained.
A did not have the power to review.
Review. Miller.
And A reviewed.
Reviewed.
But you don't know who is A. That is the whole question.
Miller. So the review is, this district magistrate has reviewed it.
Where is that power?
So there is no such power stated in the...
No such power, then the first order was also bad.
No. First order is also because the district magistrate is empowered, Miller. I am coming to show you.
Come prepared. Please
I'll
tell
show you,
us.
Miller. District magistrate is empowered to...
Please tell us tomorrow. Sorry.
Come with all provisions of law which applies to your case. And tell us. Yeah.
Item 44.
44, my lord. Agree for next week, my lord. I'm not being
Why
well.
last time?
My lord, I know, my lord. I'm ready with the matter. I have a throat infection, my lord, for that reason only. If your lordship will grant, or else I'll argue, my lord.
I'm adjourning, but we are not.
My lord may say that this is the last chance. I'll do that.
By way of last indulgence, this matter is adjourned to 1 week.
On 10th, if I pray, my lord.
Item 45.
Obliged.
May please, Lordship. The appellant before Lordship challenging the order passed in WPC number 21396 of 23 under Annexure 11, by which my appointment as associate professor, my selection appointment as associate professor in the Department of Chemistry of Fakirmon University has been quashed. The writ petitioner has been found by the single judge to be suitable, and he has been directed to be appointed in my place. That's the direction at page.
This is associate professor, not assistant professor.
No, associate professor. There is direct recruitment, madam. At page 126, that is the operative portion of the impugn order. (8.12), page 126. Therefore, this court is inclined to quash the rejection of the petitioner's claim on the ground indicated in Annexure 9. While quashing the same, this court held the petitioner suitable for her selection and appointment as against the vacancy meant for your women category for the post of associate professor in the discipline of chemistry. This court accordingly, while holding so, directs the university to provide appointment of the petitioner as against the post of associate professor in the discipline of chemistry in place of opposite party number 5. I was opposite party number 5 in the return. This court directs the opposite party number 1 to comply the aforesaid direction within a period of 1 month from the date of receipt of this order. This is the
However,
However, we observe that if the opposite party number 5 can be adjusted as against any available vacancy as an associate professor in the discipline of chemistry, necessary action be taken in this regard. Now, the case is like this. An advertisement was issued by Fakirmon University for various posts, including the post of associate professor under Annexure 1 at page 36.
So whether K. Manjusri has been reviewed by the Supreme Court? K. Manjusri decision in case of K. Manjusri, which has been referred to in the decision.
In fact, my honorable single judge has not taken into consideration the relevant the direction of the K. Manjusri at paragraph 33, wherein their lordship have said that paragraph 33 of the K. Manjusri.
K. Manjusri referred to the constitutional bench.
No, but whether constitutional bench has decided?
No, as my knowledge, I've heard that.
Please inquire.
That is not, yesterday I was searching.
Yesterday you have searched.
I could not, further I will search, man. Hey, that has not been.
Yes.
But now in the constitutional bench, it is not listed.
So yesterday I have verified, but I may be wrong, my lord. I will further verify, if my lord.
At page, annexure 1 at page 36, 2 posts were notified for associate professor in the Department of Chemistry. Both the posts are meant for your category. Out of them, one was reserved for your woman candidate. In the advertisement, also kindly see page 36. There is stipulation. In case of non-availability of suitable woman candidates, there is note appended to below the table, my lord, at page 36. In case of non-availability of suitable woman candidate, the post shall be filled up a male candidate from the same category. This stipulation contained in the advertisement is in consonance with 1994 rules. In consonance 94 rules, that is,
This is the.
there is Odisha Civil Service Reservation of Vacancies for Women in Public Services, Rule 1994. Rule 4 speaks of reservation. Sub-rule 3.
Yes.
If in any year the vacancy reserved for a particular category of women candidates specified in sub-rule 1 remain unfilled due to non-availability of suitable woman candidate belonging to the respective category, the unfilled vacancies are filled up by suitable male candidate of the same category. So therefore, the rules itself provides, though there is reservation for women candidate belonging to women category for women, if no woman candidate is found suitable, then the rule permits the authorities to appoint a male candidate belonging to the same category. So I come under that category, in fact, because in the select list, there are 2 vacancies. I was placed at serial number 2. And since no woman candidate was found suitable, naturally I was eventually been appointed against the post earmarked for you unreserved woman category.
So, for example, if there are 2 posts in SC category, 2 posts. One is reserved for female. And female is not to be found.
Yes.
In that category. Then that post has to be filled up by a male candidate of that category. But if male candidate that is to be filled up by general category candidates. This is the rule.
No, in fact, this is the rule.
That's the rule. If the SC or SC candidates are not available, that will be
yes. That is only the only
by following a procedure.
That is only ORV. That is only the Orissa Reservation Act.
Right.
ORV Act.
No, the carry forward, the general principle of carry forward, whether that will apply or not, it's a peculiar kind of provision.
That particular year, if no male candidate is there in the same category, give it to male. That's what it says.
No, then the proviso.
No, that's what it says. Provided that in case of non-availability of the male candidate or category, the vacancies are that by women candidate for general category. No preference will be given to the male same category, otherwise it's very different.
Suppose therefore I put this example of SC. And suppose
Challenge.
No, this rule is not challenged. This is the accepted, they have accepted.
The proviso is a very difficult. This is not the proviso is very difficult. This is not the fact is different.
Let me complete you. Sorry.
Yes. Acha, you are appearing against him.
No.
I am the
Writ petition.
He was the writ petition.
I am
In
the
fact,
one.
You are appearing against him.
Yes, obviously. Contesting.
My appointment was challenged by him.
Oh. We understand now. From Monday, we will make some arrangement of this thing.
Shall I go to that side?
You must.
The opposition must maintain some distance.
But the state always sit in that side. We don't have a chair to sit.
The lawyers for the petitioners
Yes.
or the applicant
Yes, there.
should be on this side.
Yes,
And those who are
They
opposing.
should not be on the same side.
should be on that side.
That creates
All
a
right, I'm
confusion.
changing my position.
That creates a confusion.
And physical distance is also required sometimes.
Yes.
Now, pursuant to this advertisement matter, 28 applications are received for the post of associate professor, including the writ petitioner, that is the respondent number 1, myself, and another respondent number 5 now. Respondent number 5. And all were asked to appear at the interview on 16/3/2020. We appeared at the interview. The select list is at Annex 3, page 45.
Yes.
Name of the candidate, page 45. Serial number 1, Tirlochan Swain, that is the respondent number 5 recommended. Pankaj Kumar Soy, the appellant before Lordship Miller recommended. There is a note below. Since no women candidate were found suitable, a male candidate was selected for URW category. So I was selected, in fact, against a post meant for women belonging to UR category. This selection of mine, pursuant to this, I was issued this selection. I was issued an appointment order under Annex 4. I joined. After 1.5 years, another writ application was filed, which came to disposed of under Annex 5. The relevant portion is at page 50. The present respondent had already approached Lordship earlier in WBC number 19275 of 2021. The order is at page 50. In this writ petition, the petition challenges the selection of opposite part number 5 as associate professor in Department of Chemistry, Fakirman University, Basavia, so and so. Then counsel for the petition submits that you'll also skip over to next page, page 51.
You were opposite party number 5 in that writ petition
Yes,
also.
ma'am.
Okay. What does the
Paragraph 6, page 51.
Okay.
It is true that this court cannot sit as a super selection committee to decide as to whether the petitioner is suitable or not. This was the finding. It is also quite apparent the reasons for unsuitability of the present petitioner has been reflected in the resolution of the selection committee. This note was omitted as well as modified. In paragraph 7, in such a matter, this court is of the view that since reservation of women candidate flows from the mandate of the Constitution of India, the said constitutional mandate has to be strictly followed. In view of such mandate, the selection committee should relook the selection process, especially with respect to selection of associate professor in the Department of Chemistry of Fakirman University, Basavia, District Baleshwar, considering the rules mean that 94 rules which your Lordship was seeing, and the advertisement dated 10/7/19 under Annex 1. In view of the above, let the university relook the entire issue afresh, as stated above, taking into account the rules and advertisement. So, therefore, the Honorable Court, the Honorable Single Judge in the earlier writ application has said that the read court cannot sit as a super selection committee to decide as to whether the person is suitable or not. But ask the authority to reconsider with regard to reservation only. That is my submission. So far the decision of the selection committee, that chapter is closed. This order was never challenged by anybody, neither myself or the read petitioner. And pursuant to this order, my lord, the university passed the impugn order under Annexure 8 at page 60. The relevant portion is at page 62. Yes, 62. Second paragraph. The views expressed by the Vice Chancellor, Chairperson Selection Committee in reply to the request of the university is that as per the advertisement dated 10/7/19, it is clearly mentioned that in case of non-availability of suitable women candidate, the posts shall be filled up by male candidate from the same category, and the selection committee unanimously decided the candidate who secured 50% or more marks in total shall be considered for the post. Accordingly, the selection procedure was conducted in setting up a uniform standard applicable for all persons. The next page, page 63, at the top, it is found that during selection process, the selection committee had fixed a limit of 50% or more as the mark to be secured by a person in order to be declared as suitable. It is the standard process adopted by the selection committee, applying it unanimously for all the posts of similar nature and with an objective to get the best candidate for teaching of students who will be future of the country. Therefore, I do not find any illegality or irregularity in the selection process conducted in the year 2019 by fixing a cut-off mark of 50%. Since Srimati Naik was the read petitioner in the other read application, could not qualify the same. So also the other two candidates who had appeared along with Srimati Naik. Therefore, the selection committee rightly considered the case of the next male candidate who secured more than 50% of marks, keeping in view the stipulation in the advertisement that in case of non-available suitable woman candidate, the male category shall be taken into consideration. Challenging this, the present writ application was filed. And it was spread in the writ application manner to quash this order under Annexure 1, and my appointment should be quashed and CB appointed. This was the prayer in the writ application. The learned single judge made a roving, and before my lord, with the lordship's permission, before lordship, I proceed to make my submission with regard to the merits of the case. Only one line, one sentence I'll submit from a very recent judgment of the Supreme Court, my lord. Only one line, AR 24 Supreme Court 135.
Yeah.
AR 2024 Supreme Court 135. Only one sentence at paragraph 84. The suitability of a candidate for appointment to a post is to be judged by the appointing authority and not by the court unless the appointment is contrary to the statutory rules or provisions. Here, my lord, as I was showing to lordship, in paragraph page 126, the honorable single judge made a roving inquiry, and having made a roving inquiry, assessed the marks awarded to the writ petitioner and held that the petition is suitable, which is not permissible. That is my first submission. Page 26, 1 second, I will place my. While quashing the same, this court held that petitioner is suitable for her selection and appointment against the vacancy meant for your woman category for the post of associate professor in the discipline of chemistry. The court has no power to determine the suitability. And such position is there since 1990. This was only reaffirmed in the recent decision. The relevant findings are at page 121 of the impugned judgment.
Yes.
This court, para 812, this court, after hearing on counsel appearing for the parties, disposed the matter by order dated 9/9/22 with the direction on the university to relook the entire issue afresh and take into account the relevant rules and advertisement issued under Annexure 1. This court in paragraph 7 of the said order clearly indicated the selection committee is to relook the selection process, especially with respect to the selection of associate professor. By referring to the order passed in the earlier writ application Annexure 5,
Yes.
the Honorable Single Judge, in fact, as I was submitting my order, such was never the direction. And in fact, it was never the contents of the writ petitioner. The writ petitioner has stated that the authority was asked to, in paragraph 13 of the writ petition, my lords may kindly see. The writ petition before original, but it is respect submitted that the order of the Honorable Court on Annexure 8 is very specific. In as much as where remitting matter, the Honorable Court has directed the selection committee to take into consideration 94 rules and the reservation made in the advertisement for River W. But surprisingly, the opposite party has overridden the order of the Honorable Court by relying upon judgment of son. So therefore, it was the case of the writ petitioner that the university was only asked to have a relook with regard to reservation alone, nothing beyond that. In as much as the Honorable Single Judge in the earlier writ application has already held that this court cannot sit as a super selection committee over the decision of the selection committee. So therefore, the decision of the selection committee has reached finality in absence of any further challenge. But here, my lord, the Honorable Single Judge has proceeded as if the entire issue is open, which is not so, man.
Yes.
Then,
so when the court finds that the marks were not properly awarded based on the research papers, based on the experience, and the court found that had that been properly done, the respondent would have qualified, and therefore the direction has been issued. So can you counter this finding?
Yes, ma'am.
That
yes,
marks were
the learned Single Judge has reassessed mark with regards to 3 items, madam. Namely, award of marks in the CCR, award of marks for the experience, and award of marks for the journals published.
For the
journals, international and national. These are 3 items on which the Honorable Single Judge has reassessed the mark. That the reassessment as made by the Single Judge is factually incorrect. In as much as so far as CCR is concerned, there is clear stipulation, all are in-service candidate. Let me kindly appreciate, all are in-service candidate. The clear stipulation in the advertisement that candidate should ensure that their CCR performance appraisal report of last 5 years should be received by the registrar of the university confidentially before the date of interview, failing which they will not be awarded the marks credit towards CCRs as provided by the statute. This was the stipulation in the advertisement
So
itself.
whether marks is provided for CCR
Yes,
also?
5 marks.
5 marks.
Yes.
So if there is nothing adverse, one will get 5 marks.
Yes.
So there cannot be any dispute over award of CCR marks.
He was awarded 0 marks. This writ petitioner was awarded 0 marks.
Zero. Why?
Because no CCR was made available. It was the responsibility of the petitioner, of the respective candidates rather, to see that the CCRs reach the
Selection committee.
That is also
He should have carried the file, or he should have got the entries met.
that is also annexed to the call letter. Call letter also, all the candidates are issued.
It would be there with the department, and the department.
No, they are serving elsewhere. They are serving elsewhere, outside candidates. In-service candidate, outside, my lord.
He was outside.
Yes, all are not working
They
in
were
the
teaching somewhere else.
Yes, working somewhere. So therefore, they should ensure that their authorities should send the CCR, or they should. That is also the stipulation in the call letter itself.
All right.
And he has not done anything.
Nothing has
to make sure that his CCR comes.
Yes,
so therefore you are awarded 0.
And all the candidates whose CCRs never reached, all were awarded 0 marks. So therefore, the petitioner also awarded 0 marks so far as CCRs are concerned.
Right. So CCR, you are equal.
No, I'm 5.
I got 5.
I got 5 in CCR.
You got 5. Your CCR was there.
Yes.
All right.
Then next is award of marks for
publication.
Yes, research publication. For research publication and experience, research experience. The Honorable Single Judge has held that he has served for 17 years. Why you have given for 10 years? In fact, the Honorable Single Judge fell into error because 8 years experience makes an incumbent eligible to apply for the post. Am I clear to us?
Yes.
So once that is excluded, the remaining years shall be awarded marks.
Suppose you have 15 years.
15 years.
8 years will be.
Unless
8 years will be taken out. Remaining 7 years
will be awarded 0.5 marks per
year.
Yes. And
no, why that has to be excluded?
Why
that?
Because that makes an incumbent eligible.
Residence period is 6 years for the purpose of eligibility. Residence period is 6 years for the purpose of qualifying certificate. Residence period is 8 years. That's what it's.
Why should that be taken out? Well, that is to be excluded. See, 8 years is the qualifying period of experience for appointment as associate professor. Now, if on the basis of experience, someone's merit is to be assessed, marks is to be evaluated, then why this 8 years is to be excluded?
Because that is the minimum eligibility criteria.
That is
to make an incumbent eligible to apply for the post. And this has also been applied.
So that must be there in the rules or advertisement.
How
do you say this?
Formula, is there any guideline or rules, anything to support that?
And what was your experience? What was, how many years you had served?
How many years you put in the service?
So in your case also 8 years must have been excluded.
Yes, it is equally made applicable to all the candidates.
So therefore that is irrelevant. If you had more experience and he did not have, again the question arises why 8 should be excluded. If 8 is to be included and on that basis
that is
they would have qualified the matter.
In fact, that is the affidavit filed by the university.
No affidavit will not do.
Yes.
We will go by the rules.
Yes.
How many years you had put in?
And what is the rule? How do you exclude this?
That is as per the UGC guidelines.
Very good. Must be there in the UGC guidelines. And you may be correct because suppose the minimum qualifying is 8 years. So someone who has just completed 8 years.
So no marks will be awarded to him.
So he may not be awarded because he has just qualified.
Yes.
So for the experience, he may not be getting any additional marks because that is the minimum qualifying.
Yes.
That may be the reasoning, but everything will depend on the language used. Just see UGC guidelines.
So that has been dealt with at page 100. Page 100, the single judge has dealt with.
Yes, that rules has been quoted.
For each completed year, 1 mark in case of PG teaching, 0.75 marks for honors teaching, 0.5 marks for graduate level teaching, subject to the maximum of 10 marks, over and above for the minimum.
Over and above the minimum prescribed years.
That's the guideline. Why are you getting 8 years with all these things? This is not.
No, it is clear.
It is already there.
It is correct.
It is already there.
You are correct. You are correct. It is specifically mentioned.
For each year.
Yes, ma'am.
Yes. Each year after the minimum period.
Minimum. Yes, ma'am.
Right.
That is subject to 10 marks.
Yes, subject to 10 marks.
Highest marks is 10.
The Honorable Single has taken exception. He has served for 17 years experience. Why he was awarded
9 years.
And the next is with regard to the journals, madam.
That is 5 marks in the international journal and 5 marks for publication in the national journal.
Total 15 marks.
15 marks.
Both for international and national journals, madam.
Why was 15?
Madam.
Each year performance appraisal 5 marks.
Can you address us tomorrow? If you're not ready?
No.
Huh?
Yes. Yes.
If you're not ready, you can come tomorrow. Or not.
May I, Primal, can
You're
it be
turning
day after
papers.
tomorrow?
Huh?
Can it be day after tomorrow?
Tomorrow.
More to your coming to the
All right, please see.
Yes.
We should try to conclude it.
Yes. Then international journals, madam, 15 marks. At page 30, I have indicated, madam. For the research publication, read petition awarded 4 marks, the breakup of which is 3 marks for publication in international journal and 1 mark for national journal. As a matter of fact, the read petition had total 7 numbers of publications. Out of them, 4 publications in international journal and 3 publications in national journal. On the contrary, this appellant had total number of 54 publications, out of which there are 32 publications in international journal, for which the appellant was awarded 6 marks, and 2 publications in international journal, for which 1 mark was awarded. Such modality of awarding marks for the journal would show that equal standards have been applied for all the candidates, including read petitioner and the appellant. So therefore, my submission is that the Honorable Single Judge has reassessed the marks, which is even as actually the Honorable Single Judge is incorrect in arriving at such a conclusion. Assuming that Honorable Single Judge is correct, such a course is not available. There are so many series of judgments that the read court cannot sit in appeal over the judgment of the selection committee. Series of judgments. And the other point is that the Honorable Single Judge has held that 50% cut-off mark, which was fixed to hold that an incumbent is suitable. Such a stipulation was neither in the advertisement nor in the rules. So therefore, that is impermissible. My submission is that there's even that even Manjushri has held the selection committee is empowered to fix a cut-off mark. Manjushri. There are three decisions of the Honorable Supreme Court. 90. Right. 98.
Notes?
No. Question is that
we have understood your propositions. Proposition wise, you just give your
yes,
written notes by day after tomorrow.
Yes,
we will try to decide it as soon as it is possible.
And my submission is that my further submission is that so far as 50% cut-off mark is concerned, madam, the Honorable Single Judge has held that there is no basis for arriving at a conclusion that the selection committee had fixed cut-off mark at 50%. In fact, it was never the case of the writ petitioner in the writ application that fixation of cut-off mark is bad or without jurisdiction. In the writ petition, entire writ petition ultimately kindly see, there is no such averment. The Honorable Single Judge, they have merely said, my lord, the selection committee has fixed 50% cut-off mark for considered suitable for candidate and also rejected claim of petitioner and other women candidates. Except this averment, there is no averment.
Okay.
No other averment.
We will see, just give you. We have understood your submissions, the factual background we have also understood. Just for the purpose of clarity, you give us the.
So my submission is that Lawrence Single Judge has made a roving inquiry with regard to assessment of marks, awarded marks, and has held the petitioner secured 50% mark. If you come to the conclusion that there is 50% mark was not provided, there is no occasional necessity to make an endeavor that 50% mark he has secured. And the selection committee, in fact, there are so many judgments of the Honorable Supreme Court, only one judgment I will cite, my lord. That is only one judgment. That is 99-1 SCC 305. Paragraph 12 at page 309.
Yes, sir, this is well settled, sir.
Yes, ma'am. So therefore, the court has no such expertise. The decision of the selection committee can be interfered only on limited grounds, such as illegality or patent material irregularity in constitutional selection committee or procedure vitiating the selection of proved malafide. There is no allegation of malafide, ma'am.
Yes.
These are the in this line there are a series of judgments, including the constitutional bench of 1964 Supreme Court, my lord.
Yes.
You give your written note then. Same principle, same principle. That's it. Same principle.
Same principle. That was also reiterated in 2023 Supreme Court also. And the finding reached by the Honorable Single Judge that is suitable without restriction, without an authority of law. And directly hits a 24th Supreme Court, which I sought to your lordship, recent pronouncement. In that 24th Supreme Court that I was showing to lordship.
Yeah, wrong.
Yes, sir. And the selection committee has power, even if there is no cut-off mark in the advertisement, even if there is no cut-off mark prescribed in the rules, still then the selection committee has power to fix the cut-off mark. Even Manjusri has also held this.
Yes. So what about that experience? What answer do you have?
Experience.
The marks on experience.
I was not given the appropriate. I have 17 years experience. My application form is there.
No, but that was to be excluded 8 years.
Yes, madam. For that remaining part also, because the records were called for by the Honorable Court, that we could not have an occasion to see. University has produced to the Honorable Court, and the
You
court
should
has-
have the occasion to see.
No, madam, because that
court-
they have produced in a sealed cover, and
Seal, even if a seal cover is again.
no, they have produced it before the Honorable
These are
Court.
not
madam. In course of
classified
hearing.
document, you can't see.
No, there was because when the Honorable Court is looking into the record, my lord, there was no need for me to relook. My lord. That was I never objected to that. Whatever the court is saying, suppose my lord is taking opinion, can I say no to that? That is the process, my lord, I have started. So now, my lord, I have 17 years experience. That was the record. There is a printed form. We have to fill it up and given it to the authority. That form is part of my writ petition. I have disclosed what are the experience I have, what are the publications I have. So everything, including that CCR part, what they are saying, there was no such provision in the form itself that we have to produce our CCR. Where from an employee will get his sub-CCR, even if I am working somewhere else. There was a column in column number 18, whether in the adverse CCR is there, whether you have been terminated from service, I'll show to the application form itself in the writ petition. So, from that, this factual aspect may be clear, because that my lord I put there.
No, but what answer do you have to the submissions that the learned single judge ought not to have gone into the correctness of the decision of the selection committee?
My lord,
item wise.
My lord, my response submission is the honorable single judge, that is he has put the second part first and the first part he has not placed it. If you read the judgment, my lord will see how the honorable single judge has gone into the matter. First round litigation, I came to this honorable court because I am a woman candidate and the post is reserved for women candidate. And then only the provision in that clause is clause 3 that I have read out. If there is non-availability of suitable women candidates, then only a man candidate can be considered. But what they have done, madam, there are women candidates. They put in a homogeneous condition. Thereafter, they are saying we have fixed a cut-off mark. And whoever is coming under the cut-off mark, they are not eligible. That is why they have given the appointment to the male candidate. For the purpose of the legislation, keeping reservation, any reservation, my lord, with my lord's vast experience, a reservation is to give some benefit to a weaker section. That is why 33% reservation to the women candidates. So if the women candidates...
That is a kind of bhashan, Mr. Khan.
My lord knows that.
Make your legal submission.
Yes, I am submitting, my lord. So if there are women candidates available in the selection.
Is it your case that the 50% cut-off mark was
not
deliberately fixed
yes,
so as to eliminate you?
That is
so that it is
that has been clearly mentioned by the Honorable Court, and that was my pleading also. I filed a document, RTI document, in the first writ petition as well as in the second writ petition. My lord, in the RTI application, another lady candidate who was also an applicant for this post, she has sought for information on RTI Act. Whether there was any cut-off mark fixed for this selection. The answer given by the university, there is no cutoff mark. But when I filed a second writ petition, because when my place was, a new plea was taken, when my case was.
Again, Mr. Counsel, we don't rely on the informations which you receive under the Right to Information Act.
No, I have not received. That is their submit, that university has given it to another candidate that was placed before the honorable court. And this
Any information supplied under the Right to Information Act cannot be relied upon by a court deciding cases based on affidavits.
My lord.
The right to information, you don't know what will happen in the proceeding under the Right to Information Act. Some information is given that is found to be incorrect. He may prefer appeal, whatever. We don't know what will happen in that proceeding.
My lord.
So, therefore, Right to Information Act, relying on those.
No, under which circumstance, I'm just stressing it, in which circumstance, in the first writ petition when I came before this honorable court, a counter was filed by the university. There was no statement that we have fixed a cutoff mark and this person is not coming within the cutoff mark. That is why his claim is rejected. This was not the stand.
What was your percentage, by the way?
Pardon me?
How? What is your percentage?
They have calculated and disclosed to the court about 48 mark. Mark they have calculated.
50 is cut off.
50 they have stated. And when I have filed it, when the case was remitted at the first instance, to see into the rules, that reservation rule and the mandate of the statute.
What was the marks scored by you in interview?
Interview. That mark that was not supplied to me exactly, my lord. That never supplied to total mark in the course of deliberation. It was stated to the court. That was I have gathered it is 48. Individual mark I don't have.
No, the marks in the experience, marks calculated in everything.
That categorization of marks so far myself is concerned, my lord, that has never been supplied to me.
Any idea? Do you have any idea?
University is there, my lord. University gets it. University is there.
Given an interview.
15 marks for mere mark for interview.
Interview, yes.
But how much did you score?
I scored 56%.
No.
Out of 15, you got 56%.
Out of 100. Out of 100. Total 100 marks.
Why was how much you got? My lord,
that bifurcation of marks we have not given. And the read petition secured 48%, and the other candidate, the respondent 5 secured 57.5.
My lord, kindly have
just we are trying with the question is for something else.
Yes, my
lord. The question is not for the.
My lord, page 121 of the judgment, my lord. Shall I read, my lord, with regard to that fixed cutoff mark, how the court has dealt with. That is the first issue the court has had. Para 8.4.
No, cutoff marks, whether this plea was taken by you in the writ petition.
Yes, that was there. Well, the judgment I am saying, that was there.
Writ petition. He says that you have not taken that point at all.
Yes, para 13 I have taken it. And the document, that document also I have filed.
8.8.21396.
121. Sorry, page.
This is writ petition number?
21396. That is the writ petition out of which this appeal arises.
Yes. Which paragraph?
Well.
Paragraph 13. At page 14. They have never challenged 50%. But surprisingly, opposite pattern 1 had overreached the order of the Honorable Court by relying upon judgment of the Supreme Court.
Well, kindly para 13.
Yes. 13. Yes. Please allow him, Mr.
Yes.
That is respectfully submitted that the order of this Honorable Court under Item 8 is very specific in as much as while remitting the matter to the Honorable Court has directed the selection committee to take a consideration on 94 rules and the reservation made by the advertisement for your women. But surprisingly, the opinion number 1 has overreached the order of the Honorable Court by relying upon the judgment of the Honorable Supreme Court, which are decided in different facts and not applicable to the present case in hand. The selection committee have fixed 50% as the cutoff mark for consideration of suitability of the candidate, and as such rejected the claim of the petitioner and other women candidate. With due respect, I humbly submit that such a stand taken by the authority is in clear violation of the rule and also illegal and arbitrary. And to this, my lord, the document, my lord, will find what I was referring to, Annexure 7 to that writ petition. Page 63. page 63 of the writ petition, annexure 7. Towards bottom column number 4. As per the decision of the selection board, towards bottom column number 4. Decision of the selection board, no women candidate were found suitable. Hence, a male candidate was selected for your women category. There is no indication of cutoff mark in the proceeding of the selection board. And now, kindly turn to the judgment of the Honorable Single Judge. Para 8.2.
Again, you have taken us to RTI.
Pardon? No, that was just referring. I am coming to the judgment.
You should not have.
No, I am not.
You should not have referred to.
Because my lord is holding.
We are repeatedly saying this.
Sorry, my lord. I'm because I'm holding the writ petition. That's what I refer it. I am just coming to the judgment. From the beginning, I am coming to the judgment. How the court has, what the new document has filed, and how the court has dealt it. Kindly turn to page 121 of this writ of
8.4.
My lord. Para 8.2, 8.3 reference to the earlier order of the Honorable Court. Thereafter, it is also found from the record that in the said writ petition, the university filed a detailed counter affidavit. In the counter, no such stand was ever taken that the selection board didn't find the petitioner suitable as he failed to secure required cutoff mark 50%. But it is found from the impugned communication under Annexure 9, the claim of the petitioner in terms of the earlier order passed by this court has been rejected only on the ground that the petitioner has failed to secure the cutoff mark 50%. Since the earlier writ petition, it was never the stand of the university that the petitioner was not selected as he could not secure the required 50% cutoff mark. The said plea which has been taken while rejecting the claim of the petitioner Annexure 9, as per the considered view of this court, is not sustainable in law, eye of law. It is also found that the opposite part number 1, while rejecting the petitioner's claim by Annexure 1, simply relied on the communication issued by the chairman of the selection board, who happens to be the earlier vice chancellor of the university, so issued under Annexure A to the counter affidavit. This court, after going through the said annexure, finds that the chairman of the earlier selection board was also not sure with regard to fixation of such cutoff mark 50%. The view of the chairman of the earlier selection board reflected in para 2 reads as follows. 2. As far as I remember, the selection committee unanimously decided that the candidate who secured 50 or more mark in toto shall be considered as suitable for the post. Since it is found from the record that no such cutoff mark was ever fixed, which is also fortified with the information provided by the university under Annexure 7 and the stand of the chairman of the selection board, so indicated in para 2 of Annexure A, it is of the view this court that the rejection of the petitioner claim on the ground indicated in Annexure 9 is not sustainable in law, taking into account the stand of the petitioner that the petitioner was not awarded proper mark with regard to the teaching experience as well as the research publication. This court, while hearing the matter, directed Land Council appearing for the university to provide the selection file with regard to selection as against the post of associate professor in discipline of chemistry. The same, after being produced by the Land Council for the university, was also perused by this court. On bare perusal of the selection file, it is found that even though the petitioner, in support of her teaching experience, provided required certificate showing her teaching experience at 17 years, but the same was calculated at 10 years with award of only 5 marks out of prescribed 10 marks. It is also found that petitioner, out of 10 marks provided for research publication for international journals, she has only been awarded 3 marks as against the publication of international journal and 1 mark as against the publication of 5 national journals. No mark has been awarded towards CCR appraisal in favor of the petitioner. This court, after going through the selection file, when found that the proper mark has not been awarded with regard to the research publication and teaching experience as well as the CCR appraisal, the matter was listed on 18/10/23. This court passed the following order. This matter was taken up through hybrid arrangements also. This matter was listed in order to clarify certain queries with regard to award of mark to the candidates in terms of the advertisement issued under Annexure 1. This court, after going through the selection file so produced by the Land Council for the university, finds that the award mark in different heads finds that nothing has been indicated with regard to the basis for awarding the mark towards research publication and CCR appraisal. Nothing has been indicated as to how many publications in international journal a candidate has to produce in order to get the publication 10 mark and how many publications in national journal to get prescribed 5 mark. Similarly, with regard to award of 859 mark of CCR appraiser, no basis has been prescribed. In such view of the matter, this court directed Land Council appearing for the university to apprise this court about the method of award mark with regard to research publication and CCR appraisal and the basis of adopted by the selection committee to award such mark. Is requested by Mr. P. Mahapatra and counsel for the petitioner. Please this matter on 11143 under had mention. To mention the original selection file so produced by Mr. Mahapatra and counsel is returned with the due acknowledgement for the purpose of getting instruction as directed by this court. In terms of the order dated 18/10/23, Land Council appearing for the university produced the relevant record with regard to award of mark in favor of the candidates with regard to research publication, teaching expression, as well as CCR appraisal. This court, after going through the record, finds that no uniformity has been maintained by the selection board in awarding mark towards research publication, teaching expression, as well as CCR appraisal. Nothing is also on record with regard to the basis for award of mark in favor of the eligible candidate in the aforesaid three categories, that is research publication, teaching expense, as well as CCR appraisal. Therefore, it is the view of this court that the selection board has conducted the selection in a very haphazardly manner and awarded mark in absence of any fixed criteria. On bare perusal of the mark awarded by the selection board, it is also found that the selection board had not awarded.
1 minute, please.
Annexure 1.
Page 36. Ten 7/19.
Yes, ma'am.
Yes,
Appeal.
yes, yes. 10/7/2019.
Yes.
Application in the prescribed format, one copy are invited from eligible candidate for recruitment to the following teaching post as mentioned against each.
Of the appeal.
Yes, well, yes. Yes. Page 36. Annexure 1.
36. Where are you reading?
Well, page 36.
Oh, no. Which part?
Again?
Which part of that?
Yes, the first part.
Yes.
Just kindly say application in prescribed format and copy of invited application eligible candidate for recruitment to the following teaching post as mentioned against each of different postgraduate department of procurement university Balasore. Consequently, university advertisement of so and so hereby stand cancelled. Candidates who have submitted their application pursuant to the aforesaid advertisement required to submit their application appraised without application. Now, serial number 4 is the chemistry. Chemistry, name of the post vacancy. 1, you are associate professor. We are concerned about associate professor. 2, you are women
W1. That you are concerned about.
Your mark. Yes. 1 for women and 1 for male. So when there are
and that women post has gone to him.
That's him. That is the problem. That is the issue. And the reservation, my respective submission is, if that will, when I am eligible and I have been allowed to participate in the process of selection by fixing an artificial cutoff mark, which is not there in the initial point. That is what the my lord have also.
But the finding of the learned single judge is that the entire selection process is vitiated.
Vitiated.
If you want to sustain that, the entire selection has to go.
Yes, it could have. Because that selection, because there are women candidates, my humble submission is at this juncture. Since there are women candidates, the selection should have been confined to the eligible women candidate. If there is
the findings are the entire marking is the
entire
whole process is vitiated. If that is to be sustained, then the entire selection has to go. Why should you get it?
Because I am a woman candidate.
Merely because what?
And I have not been awarded marks in respect of the subject where I got, my lord, the CCR. Because there is no provision to place the CCR. I could not place the CCR. The column is the application form, if I read it. At column number 18, my lord will have it in the writ petition. I have given my application form. Can you see? Page 29 of the writ petition.
No, that is not relevant. They are the employer.
Yes, ma'am.
So if they don't get them, not award marks.
No, but what is the requirement I am just saying?
What is the requirement?
Requirement they say for the CCR, my lord.
Yes.
The column says, column number 18 of the application. It is in a questionnaire form. Have you ever been subjected to any disciplinary action as student and as an employee? I said no. And two, have you ever been dismissed, suspended from service? I said no. And entire column I have gone through, there is no provision to produce the CCR as such. This is the only column available in the application form.
No, whether marks was to be awarded.
CCR, yes, that is the statute, my lord. That is the university statute.
Then what is wrong in that?
I have not been awarded mark. Not a single mark.
Rightly not been awarded mark. Because the CCR was not available.
My lord, fault. If then, my lord, the non-availability of the CCR cannot be faulted.
No, yes.
94
So
Supreme
it
Court.
have to be faulted because if the employer was someone else, the employer had this university been the employer, the matter would have been different.
My lord, I cannot carry the CCR with me. The CCR is never
make
handed over.
submissions, please. We know that you are counsel of some standing. Please don't make this submission.
No, my lord. 1994 Supreme Court, that V. Kashyap case, my lord knows.
No, that is interdepartmental. That is not intra.
No, my lord. What the Supreme Court has held, if non-availability of CCR cannot be faulted, the employee cannot be faulted with.
How can you argue this?
That is the judgment.
If it is
department, yes,
intra-departmental this thing, then you can give the responsibility to them. Equally, he got the CCR, and he got the mark.
With your lordship,
what to do?
The lordship's permission, my lord. The call letter issued to all the candidate states. The candidate may also bring it in a sealed cover and submit on the date of interview. If this is not received in due time. Annexure 2, page 44.
44.
That is call letter. Identical call letter has been issued to all the candidates with this stipulation, my lord. Column 6. The CCR PAR for last 5 years for the candidates who reach the university honor before the interview. The candidate may also bring it in a sealed cover and submit it on the date of interview. If this is not received in due time, marks will not be awarded on this head.
Yes.
So therefore, it is also the responsibility of the candidates to bring the CCRs in the event their employers do not send, my lord.
44. 44. 6 plus 6.
That's all. That's all.
And that only one paragraph I've left, my lord. Shall I complete? That kindly see. Paragraph 8.11.
What is your answer to 6?
This
page 44 and 6.
6, my lord. Instantly, I cannot give the answer whether he has given it because
answer it. It's clear and simple English. Just answer it. You have to take it in a seal cover and give it. If you don't give, you don't get.
Whether he has given it or not, that.
No marks is given, that is an admitted fact. Now you can't improve.
No mark has been given in one aspect. Whether he has submitted or not, that aspect, my lord.
Then whether that is there on record or not.
Record was before this honorable court and my friend.
Mr. Counsel, you had filed your writ petition.
My lord.
You were knowing what records were submitted by you. Why are you saying you don't?
No, that is correct. But instantly, I cannot give the correct answer.
Your wrong writ petition is there.
Yes, sir.
So
that is true.
So wrong writ petition. Your pleadings.
There are 2 rounds of litigation you have initiated.
Yes.
Two
Mr.
writ petitions
Counsel, you
filed.
should briefly phrase the question put by the
My
court.
lord, I am
Yes or
obliged.
no?
Yes, my lord. I am obliged, my lord. In the writ petition, I have only stated that I have filled up the application form as per the norms.
Yes, University, please sit down.
Bye.
Yes, Ms. Mohammed.
Just bring the reports again. We'll have to see whether the findings are correct or not.
Yes, I will bring that record again. Only I will point out one line, one document, my lords. Here in this case, what happened? My lords directed me to produce the documents. I produced the documents. And before that, I prepared a note and I have also given it in form of an affidavit. That is what is the lacking and what insofar individual cases are concerned. I made a jot down at the whole total points and I given it so far that research publications, how it has been calculated, and what is the Thomson-Reuters method and how Thomson-Reuters method is being the assessments are made under that process by the experts. It is mentioned in Annex 9. This is what it is in Annex 9. Page minus 65 in the writ opinion.
Yes.
There I've stated in detail, there I've stated all this. Produce the documents and I've stated all this. My humble content is what my learned brother minors relied upon the commissions before the Annex 9.
Annex 9.
Page 65, my lord. 65.
Which paragraph is that?
First paragraph will start. It starts from also the I quoted first paragraph. I quoted the
petition or
no, must in the appeal memo. My lord and friend, but relied upon that. That I filed in the repetition, but that has been enclosed as Annex 9 to the writ.
All right.
There are categorically stated about the provision of the CCR.
Which paragraph?
Paragraph 4, my lord.
4.
Page 68. 68, my lord.
68.
Yes.
Paragraph 6 and onward, I've stated about the process of selection, but assessment of the publications with reference to the UGC guideline. I enclose this UGC guideline matters. That is at Annex A, page starting from page 75. All these matters, the document, these affidavit have been filed to all before filing before the honorable. Along with the matters, the record documents and records called for.
You are referring to page 75.
Well, 75, this is UGC guideline. This UGC guideline matters refer to the very typical method of assessment that we simply cannot understand.
Take into consideration the impact factor and all.
Impact factor and all these things, page 80, 80. There, the experts, the 3 experts will be there in the committee. They have to assess. Suppose, I have 5 publications in National Journal, but 2 or 3 publications, 2 or 3 publications, they may feel it is not so important.
One publication may be of first standard.
So yes, madam. There, that is what UGC framed the guideline. So far, other parts are concerned. One part is being dealt. So far, CCR and all these things are being dealt with the other university statute. My on single bench already quoted that provision. I've given that copy also. That is there. They've stated, but he has not provided the CCR. She has not provided the CCR. Not been awarded with the mark. That is also I've stated in this affidavit. That minus wanted. I will again call for that files, original files, and produce it minus. Now, so far, minus that minimum eligibility, minus my all along my consistent case is that it is the selection committee. This is their subjective satisfaction. It is not that they have to say that it is 50% or not, because Honorable Court wanted. That is what we required. The Vice Chancellor then, who are the chairman of the committee, what was your view? Because other members were not. It is not a standing committee.
Selection committee is not a standing committee.
Right.
It is being constituted for the purpose only. Thereafter it goes out. But so with just away. But here the ex-vice chancellor said that we made up our mind to fix 50%. So there is no contingency of writing it. That is their subjective satisfaction. So, but selection committee and subjective satisfaction, but otherwise there will be no meaning of the selection committee.
In the spot, they take a call.
They take a
that,
decision.
yes, this is
that
the
is what this is the
cut-off mark we will fix.
Yes,
It.
madam.
That is how selection goes.
That is what it is requirement of the selection committee. Madam, this is the objective to form a selection committee. Now, madam, one thing I am arguing is here in this case, suppose madam, what Miller says, suppose the whole total selection process is vitiated, is found vitiated. Would have been passed Miller. Now the law has been changed. Now it will go to OPSC. OPSC will consider it and that they will take a decision in this regard. But here in this case, my lords, I have given all the details, considering all these things, considering my submissions.
Your affidavit was filed in the petition.
Yes, my lord. In the writ petition, pursuant to my lord's filing of the documents, in support of that, I filed an affidavit stating the detailed particulars again. What has happened so far that individual, so far the assessment of the CCR, assessment of the paper publication and all these. 3 points have been raised and all the 3 points have dealt with. Enclosing that UGC guideline. And so far impact factor is concerned, is very difficult in our part to appreciate except the experts panels.
No, these are expert.
Except expert panels. Impact factor. I tried to understand, but I could not be able to appreciate this. And in this case, I found 3 marks have been awarded in so far the national publication, 1 mark has been awarded in respect of rebalance international publication. That also I quoted.
Yes.
I produce my notes after whatever document I produce so far that petitioner and opposite parties. My notes, if my notes required, my notes directs, I produce this. If requirement.